Code on Wages, Central, Rules, 2020, FAQs. These official guidelines from India's Labour Ministry implement comprehensive wage laws that protect workers' rights while providing employers with clear payment obligations and compliance procedures. Essential questions and answers about India's wage code rules in straightforward language. What are the Code on Wages, Central, Rules, 2020? These are regulatory frameworks established by India's Labour Ministry that translate wage legislation into practical implementation. They provide detailed guidance for employers and workers regarding payment methods, minimum wage calculations, and other critical wage-related matters. These rules operationalize the Code on Wages, 2019, which consolidates and replaces 4 previous labor laws. Who developed these rules? The Ministry of Labour and Employment of the Indian government formulated these rules. A specialized committee comprising ministry officials and subject matter experts drafted them following comprehensive consultations with key stakeholders, including industry associations, trade unions, and state government representatives. What legal authority supports these rules? The government's authority to establish these rules stems from Section 67 of the Code on Wages, 2019, and Section 24 of the General Clauses Act, 1897. This legal foundation ensures nationwide enforcement and implementation capabilities. Why are these rules significant? These rules safeguard workers' rights to fair compensation while providing employers with clear guidelines regarding wage obligations. They establish standardized wage definitions throughout India, streamline compliance requirements, and reduce regulatory complexity. Additionally, they ensure prompt wage payments and provide transparent frameworks for calculating minimum wages. When will implementation begin? The rules will take effect following the completion of the official notification process and public comment period. The draft rules were published on July 7, 2020, allowing a 45-day window for public input. The final rules will be published in the official gazette after addressing stakeholder feedback, with implementation commencing thereafter. What key innovations do these rules introduce? The rules establish a new system for determining minimum wages based on skill classification and geographic considerations. They create a unified definition of wages to replace multiple previous interpretations, and introduce updated standards for working hours, overtime calculation methods, and payment procedures. How will workers benefit from these rules? Workers will gain from enhanced wage calculation transparency, timely compensation, appropriate overtime payment, and simplified grievance procedures. The rules also extend protections to previously excluded worker categories, broadening the safety net. What implications do these rules have for employers? Employers must adapt their payroll systems to align with the new wage definition, maintain specified documentation requirements, and ensure prompt wage disbursement. However, the consolidated code significantly reduces the multiple compliance obligations that existed under the previous fragmented laws. Frequently asked questions. The Code on Wages Rules, 2020 notification was published on July 7, 2020, with a 45-day public comment period. Comments must be sent to designated ministry officials, and the rules will be implemented only after final publication in the official gazette. Common questions about the notification and implementation timeline of the Code on Wages Rules, 2020. When was the notification for Code on Wages Rules published? The Ministry of Labour and Employment published the notification on July 7, 2020, officially recorded as GSR 432-E in government records. This publication marks the first step in the official rule-making process. How long is the public comment period for these rules? The public comment period extends for 45 days from the date the official gazette becomes available to the public. This period allows stakeholders, including workers, employers, and industry associations, to provide valuable feedback on the proposed rules. Who should receive objections or suggestions about these rules? All objections and suggestions should be directed to Shri M.A. Khan, Deputy Director, and SMT, Rashana Balimra, Assistant Director at the Ministry of Labour and Employment. These designated officials are responsible for collecting and organizing all feedback for ministerial review. What is the required format for submitting comments? Comments must be submitted in writing, clearly identifying the specific rule being addressed along with proposed changes or concerns. Both electronic submissions via email and traditional paper submissions are acceptable. Will all submitted comments be considered? Yes, the ministry is required to review all properly submitted comments received within the 45-day time frame. Each submission will be documented and evaluated during the comprehensive review process. Can submissions be made anonymously? No. All submissions must include the name and contact information of the individual or organization providing feedback to be formally considered in the review process. When will these wage rules actually take effect? The rules will come into force only after their final publication in the official gazette, which occurs after the government reviews all public comments and makes any necessary revisions. The exact implementation date will be specified in the final notification. Will there be a transition period for employers to adapt to the new rules? Yes, the final notification typically includes provisions for a reasonable transition period, allowing employers sufficient time to update their systems and processes to comply with the new requirements. Frequently asked questions. The Code on Wages 2020 consolidates and replaces 4 major labor laws related to wages, minimum pay, bonuses, and equal remuneration to streamline India's labor regulations. Essential information about the Code on Wages 2020 and the previous regulations it replaces, explained in clear terms for both employers and employees. What does the Code on Wages 2020 replace? The Code on Wages 2020 replaces 4 major labor laws: the Payment of Wages Act, 1936, the Minimum Wages Act, 1948, the Payment of Bonus Act, 1965, and the Equal Remuneration Act, 1976. This consolidation brings all wage-related regulations under a single unified framework, which rules about wage payments are no longer used. The Payment of Wages Procedure Rules, 1937, and the Payment of Wages Nomination Rules, 2009, have been superseded. The new code incorporates these procedural aspects into a more comprehensive and streamlined system for wage administration. What minimum wage rules does the new code replace? The code replaces the Minimum Wages Central Rules, 1950, and the Minimum Wages Central Advisory Board Rules, 2011. The new provisions create a more uniform approach to determining minimum wages across different sectors and regions throughout India. Are there other labor rules that the Code on Wages replaces? Yes, the code also replaces the Payment of Bonus Rules, 1975, Equal Remuneration Rules, 1976, and Central Advisory Committee on Equal Remuneration Rules, 1991. This integration eliminates the previously fragmented regulatory landscape that complicated compliance. Why were all these rules combined into one code? The consolidation aims to simplify labor regulations, ensure consistency in application, and reduce the compliance burden. This unified approach minimizes conflicting interpretations, facilitates business operations, and strengthens enforcement mechanisms for worker protections. What are the main benefits of this consolidation? Key benefits include simplified compliance for employers, standardized definitions across previously separate laws, broader worker coverage, improved wage determination processes, enhanced enforcement provisions, and greater clarity on wage payments, deductions, and minimum wage calculations. How does this affect existing wage structures? Employers must review their existing wage structures to ensure compliance with the new code. The introduction of a floor wage concept establishes a national baseline for minimum wages. Organizations need to align their compensation practices with updated provisions for overtime pay, deductions, bonus calculations, and equal remuneration principles. Frequently asked questions. Code on Wages Central Rules. These nationwide rules implement the Code on Wages 2019, establishing a comprehensive framework to regulate wages, minimum pay, and worker compensation across all employment sectors in India. What are these rules called? These regulations are officially titled the Code on Wages Central Rules 2020. Where do these rules apply? The Code on Wages Central Rules have jurisdiction throughout the entirety of India. When do these rules come into effect? These rules become effective on the date of their publication in the official gazette, coinciding with the implementation of the Code on Wages 2019. What purpose do these rules serve? These rules provide detailed guidelines for implementing the Code on Wages 2019, governing wage payments, minimum wage determinations, and other compensation-related matters across all employment sectors. Who established these rules? The central government formulated these rules by exercising its rule-making authority granted under Section 67 of the Code on Wages 2019. Who must comply with these rules? These rules apply universally to all employers and employees throughout India, encompassing both the organized and unorganized sectors, regardless of industry or establishment size. What happens to previous wage regulations? Upon implementation, These rules supersede all previous regulations relating to payment of wages, minimum wages, bonus payments, and equal remuneration, creating a unified regulatory framework. How are minimum wages determined under these rules? The rules establish a systematic procedure for minimum wage determination based on workers' essential needs, skill classification, work difficulty, geographical considerations, and other relevant factors as determined by appropriate government authorities. What is the frequency for minimum wage revision? The appropriate government must review and revise minimum wage rates at intervals not exceeding 5 years, ensuring wages remain relevant to economic conditions. What consequences do employers face for non-compliance? Non-compliant employers may face graduated penalties including substantial monetary fines and, for serious or repeated violations, imprisonment is stipulated in the enforcement provisions of the Code on Wages, 2019. Frequently asked questions. This section explains key administrative terms used in the Code on Wages, including authorities, appeal processes, and advisory bodies. Common questions about the important terms used in the Code on Wages, explained in simple language. What is an authority under the Code on Wages? An authority is an official or committee appointed by the central government under Section 45 of the Code to resolve disputes, enforce wage regulations, and ensure compliance with wage-related provisions. What does appellate authority mean? The appellate authority is a senior official appointed by the central government under Section 49, who reviews appeals against decisions made by an authority. They serve as a higher review level to ensure fair resolution of wage-related disputes. What is the board mentioned in the Code? The board refers to the Central Advisory Board, a panel of experts established by the central government under Section 42. This board provides recommendations on minimum wages, worker welfare policies, and other wage-related matters at the national level. What is meant by the Code? The Code specifically refers to the Code on Wages, 2019, Act 29 of 2019, which is the comprehensive legislation that consolidates and regulates all aspects of employee compensation, minimum wages, and payment procedures throughout India. What is the appropriate government in the Code? The appropriate government refers to either the central government or a state government, depending on which has jurisdiction over a particular establishment or industry. This designation determines which government entity is responsible for implementing and enforcing specific provisions of the Code. What is an inspector cum facilitator? An inspector cum facilitator is an official appointed under Section 51 with dual responsibilities. They monitor workplaces to verify compliance with the Code while also guiding employers and workers on proper implementation of wage regulations, effectively combining enforcement and educational roles. What is the State Advisory Board? The State Advisory Board is a state-level expert committee established under Section 42 that advises the state government on implementing the Code, setting regional minimum wages, and addressing wage-related issues specific to that state's economic and labor conditions. What is a tribunal under the Code? A tribunal is a quasi-judicial body appointed by the appropriate government under Section 44 to adjudicate complex wage-related disputes. Tribunals handle cases involving significant monetary claims or important legal principles, providing a specialized forum for wage dispute resolution. Frequently asked questions about job types. Jobs are classified into 4 categories based on required training and expertise: highly skilled, skilled, semi-skilled, and unskilled. Below are answers to common questions about different job categories and their skill requirements, qualifications, and representative positions. What is a highly skilled job? A highly skilled job requires advanced specialized training and expertise. These positions demand extensive education, typically including advanced degrees, professional certifications, or specialized technical training. Preparation generally involves 4+ years of focused study and ongoing professional development. Examples include physicians, engineers, software architects, research scientists, and senior executives. These roles command higher compensation and require sophisticated problem-solving abilities, critical thinking, and deep domain knowledge. What is a skilled job? A skilled job requires specific technical abilities acquired through formal training or substantial experience. These positions typically require 4 years of training through vocational education, technical schools, apprenticeships, or accumulated work experience. Examples include electricians, plumbers, accountants, registered nurses, and web developers. These jobs demand technical proficiency, precision, and specialized knowledge in particular fields. What is a semi-skilled job? A semi-skilled job requires moderate training and familiarity with specific processes or equipment. These positions typically need several months to a year of training or practice, with most skills developed through on-the-job experience. Examples include machine operators, customer service representatives, retail sales associates, and commercial drivers. These roles involve following established procedures and maintaining a basic technical understanding of specific equipment or processes. What is an unskilled job? An unskilled job requires minimal specialized training and can be learned quickly. Training typically spans days or weeks rather than months or years. Examples include custodial staff, general laborers, agricultural workers, food service personnel, and warehouse packers. These positions emphasize reliability, physical capability, and the ability to follow clear instructions rather than technical expertise. These four classifications help categorize different types of work based on training requirements and expertise levels. This framework guides the determination of appropriate wage structures, development of training programs, and creation of skill advancement pathways across various occupations. It's worth emphasizing that all job categories contribute essential value to the economy and society, regardless of their skill classification. Minimum wage calculation. Common questions. Minimum wage calculations are based on supporting a family of four, covering essential needs including nutrition, 2,700 calories day, clothing, 66 meters year, and housing, 10% of food clothing costs. Here are answers to frequently asked questions about how minimum wage requirements are calculated. What is considered a standard family when calculating minimum wage? A standard family consists of a worker, their spouse, and 2 children, equaling 3 adult consumption units, as children count as partial units. This standard family size was established by the 15th Indian Labor Conference as the basis for minimum wage calculations. How much food should minimum wage cover? Minimum wage should enable each family member to consume approximately 2,700 calories daily, which meets the nutritional requirements for individuals engaged in moderate to heavy physical labor. This caloric standard ensures workers and their families maintain adequate energy and health. Does minimum wage include clothing expenses? Yes, minimum wage calculations incorporate an allowance of 66 meters of cloth per year for a standard family. This provision ensures all family members have sufficient clothing throughout the year, accounting for seasonal changes, regular replacement needs, and reasonable wear and tear. How is housing cost calculated in minimum wage? Housing rent is calculated at approximately 10% of the combined food and clothing expenditure. This formula aims to ensure working families can afford adequate shelter, while maintaining a balanced allocation of resources for all essential needs. Are there regional variations in minimum wage calculations? Yes, minimum wages typically vary by region to reflect differing costs of living. Urban areas generally have higher minimum wages than rural areas to compensate for elevated housing, transportation, and general living expenses in city environments. How often should minimum wage be revised? According to established best practices, minimum wage should undergo annual review and potential adjustment to account for inflation and changes in living costs. This regular reassessment helps preserve workers' purchasing power and ensures wages remain aligned with economic realities. Does minimum wage account for savings? While the basic minimum wage formula doesn't explicitly include a savings component, a properly calculated living wage should allow families to set aside modest savings after covering all essential expenses. This provides some financial security and capacity for emergency expenditures. Understanding these calculation factors provides insight into how minimum wage levels are determined and what basic living standards they are designed to support for working families across different regions. Common questions about minimum wage requirements. Minimum wage calculations must include additional allowances for utilities, 20%, and essential services, 25% beyond basic food, clothing, and housing needs, as established by the Supreme Court and Indian Labor Conference. Here are answers to frequently asked questions about additional components of minimum wage calculations. What extra expenses must be included in minimum wage calculations? Minimum wage must include 2 key additional components: utilities. 20% of the minimum wage must cover basic necessities such as fuel, electricity, water supply, and cooking gas. 1. Essential services. 25% must provide for education, medical care, recreation, transportation, and contingency expenses too. Who established these requirements? The Supreme Court of India in the landmark Ratakis-Brett case, 1992, which mandated the 25% essential services component. The 15th Indian Labour Conference, which initially formulated these foundational principles. The Fair Wages Committee, whose comprehensive report laid the groundwork for these calculations. Why are these additional allowances necessary? These allowances ensure workers can access basic services beyond mere subsistence needs of food, clothing, and housing. They help establish a more comprehensive living wage that addresses all essential needs of a working family. Without these provisions, workers would need to sacrifice education, healthcare, or other vital necessities. They acknowledge that a meaningful minimum wage must support quality of life, not just basic survival. How does this differ from the basic minimum wage? The basic minimum wage covers only fundamental food, clothing, and housing requirements. These additional percentages ensure workers can also afford utilities, education, healthcare, and maintain emergency funds. The comprehensive minimum wage represents approximately 45% more than the bare subsistence minimum wage. How frequently are these components reviewed? The Pay Commission conducts periodic reviews of these components alongside other wage considerations. State-level minimum wage advisory boards may recommend adjustments based on regional economic conditions, while the percentage allocations have remained consistent since the Supreme Court ruling. The actual monetary values adjust with inflation. Do these components apply universally to all workers? Yes. These components apply to all categories of workers protected under minimum wage legislation. They remain consistent across industries, skill levels, and employment categories. Both formal, organized, and informal unorganized sector workers are entitled to these provisions. How do India's requirements compare internationally? India's approach of designating specific percentages for utilities and essential services is relatively distinctive. While many countries employ different methodologies, most aim to achieve similar comprehensive coverage. The International Labour Organization (ILO) recognizes India's framework as a valid approach to ensuring living wages. Wage rate conversion. Frequently asked questions. Daily wage is the standard unit for all wage calculations. Convert to hourly by dividing by 8, to monthly by multiplying by 26, and always round fractions of 0.5 or more up to the next whole number. Essential questions about wage rate conversions. What is the basic unit for calculating wages? The daily rate serves as the fundamental unit for all wage calculations. This standardization ensures consistency across different employment types and industries, providing a common reference point for all conversions. How do I calculate the hourly wage from a daily wage? Divide the daily wage by 8 to determine the hourly wage. For example, a daily wage of 800 yields an hourly wage of 100. This calculation reflects the standard 8-hour workday established in labor regulations. How do I calculate the monthly wage from a daily wage? Multiply the daily wage by 26 to calculate the monthly wage. For instance, a daily wage of 500 results in a monthly wage of 13,000. The factor of 26 represents the average number of working days in a month, excluding weekly rest days. How should I handle fractions when converting wages? Follow the straightforward rule. Round up to the next whole number if the fraction is 0.5 or higher. Round down, discard the fraction if it's less than 0.5. This approach ensures fair compensation when dealing with partial amounts. Why is the daily rate used as the standard calculation? The daily rate provides a versatile measurement unit that easily converts to other time periods using simple formulas. It also aligns with traditional labor practices across numerous sectors, where work compensation is traditionally calculated on a per-day basis. How do I calculate overtime wages? Calculate overtime at twice the normal hourly rate. First, determine your hourly rate, daily wage %8, then multiply by 2 for each overtime hour. For example, with a daily wage of 800, your hourly rate is 100, making your overtime rate 200 per hour. What if I work part-time or less than 8 hours? For partial workdays, calculate your pay by first determining your hourly rate, daily wage %8, then multiply by your actual hours worked. This ensures you receive proportional compensation for shorter shifts. How do I calculate annual wages from daily wages? Multiply your daily wage by 312, 26 days x 12 months, to determine your annual wage. For example, a daily wage of 500 translates to an annual wage of approximately 156,000. This calculation accounts for paid weekly rest days throughout the year. Are there any exceptions to these conversion rules? Certain industries and job categories may follow specific conversion factors established in their regulations or collective bargaining agreements. Always verify the rules applicable to your particular employment situation with your employer or labor department. Geographical classification for minimum wages. Areas are classified into 3 categories: metropolitan, non-metropolitan, and rural based on population size, with different minimum wage rates applying to each classification to account for varying living costs. Common questions about geographical classifications for minimum wage determinations. What are the different area types for minimum wages? There are 3 classifications: metropolitan areas, non-metropolitan areas, and rural areas. Each category has specific minimum wage rates that reflect the local cost of living. This tiered system ensures workers receive compensation appropriate to their region's economic conditions. What is a metropolitan area? A metropolitan area is defined as a compact region with a population of 4 million or more, potentially spanning multiple districts. These areas feature higher economic activity, developed infrastructure, and elevated living costs. Major cities and their surrounding urban agglomerations typically fall into this category. What is a non-metropolitan area? A non-metropolitan area has a population between 10 lakh, 1 million, and 40 lakh, 4 million, within a compact region, possibly covering multiple districts. These areas represent medium-sized cities or developing urban centers with moderate living expenses compared to metropolitan regions. What is a rural area? A rural area encompasses any region not classified as metropolitan or non-metropolitan. These areas typically have smaller populations, less developed infrastructure, and lower living costs. This category includes villages, small towns, and agricultural regions with populations below 10 lakh, 1 million. Why are areas classified this way? This population-based classification system accounts for regional economic variations. Metropolitan areas generally have higher housing, transportation, and general living costs than rural areas. These distinctions ensure minimum wages appropriately reflect each area's economic reality and cost of living. Who determines the classification of an area? The appropriate government authority establishes area classifications based on current census data and relevant demographic indicators. These designations undergo periodic review to maintain accuracy as populations and development patterns evolve. Can an area's classification change over time? Yes, classifications may shift with demographic changes. For instance, a non-metropolitan area experiencing significant population growth might be reclassified as metropolitan during subsequent reviews. Regular government assessments ensure classifications remain current and accurate. How much do minimum wages differ between these areas? Minimum wage variations follow a consistent hierarchy. Metropolitan areas have the highest rates, followed by non-metropolitan areas, with rural areas having the lowest. These calibrated differences reflect varying living costs while ensuring workers in all regions can meet their basic needs. Do all workers in the same area receive the same minimum wage? No. Within each geographical classification, minimum wages further vary based on skill level. Unskilled, semi-skilled, skilled, and highly skilled, and employment sector. The geographical classification represents one of several factors determining a worker's appropriate minimum wage. Technical Committee for Skill Categorization, FAQs, a specialized committee chaired by the Chief Labor Commissioner that systematically classifies occupations based on skill requirements to establish equitable minimum wage standards. With representation from key government ministries and wage policy experts, frequently asked questions about the committee responsible for occupational skill classifications in minimum wage determination. What is the Technical Committee for Skill Categorization? This specialized committee establishes classification frameworks for occupations based on skill requirements. These classifications serve as a foundation for determining appropriate minimum wage rates across different skill levels. The committee conducts comprehensive evaluations of occupational roles across industries to categorize them as unskilled, semi-skilled, skilled, or highly skilled. Who chairs the committee? The Chief Labor Commissioner Central serves as the chairperson, providing leadership for all committee activities. The chairperson ensures that skill categorizations remain aligned with national labor policies and broader economic objectives. Who are the primary members of the committee? A joint secretary from the Ministry of Labor and Employment with portfolio responsibility for wage-related matters, a representative from the Ministry of Skill Development and Entrepreneurship, the Director General of Employment from the Government of India. What additional members comprise the committee? 2 wage determination experts appointed by the central government based on their specialized knowledge and experience, a Deputy Secretary from the Ministry of Labor and Employment focusing on wage policies, who serves as the member secretary. What is the committee's meeting schedule? The committee convenes quarterly as standard practice, with provisions for extraordinary sessions when emerging industries or significant occupational transformations necessitate reassessment of skill categories. Each formal meeting requires a minimum quorum of 4 members, including the chairperson. What methodology does the committee employ for skill level determination? The committee applies a multifaceted assessment approach that considers educational qualifications or technical certifications required for competent performance, relevant experience necessary for proficient job execution, task complexity and scope of decision-making, authority, degree of supervision required or exercised, physical and cognitive demands inherent to the occupation. Is there an appeals process for committee decisions? Yes. Stakeholders including employers, trade unions, and industry associations may submit formal appeals when they believe an occupational classification requires reconsideration. Appeals must include substantiating documentation and may necessitate in-person representations before the committee during a formal hearing. Why is this committee's function significant? The committee plays a crucial role in ensuring equitable skill-based worker classification, which directly impacts minimum compensation requirements and protects workers' economic rights. Furthermore, the committee's standardization efforts promote consistency across industries, minimize wage-related disputes, and contribute to labor market stability during evolving economic conditions. Dearness allowance revision, a twice-yearly adjustment to minimum wages that helps workers maintain their standard of living amid rising costs of essential items like food and housing. What is dearness allowance? Dearness allowance is a supplementary payment added to employees' minimum wages to offset the impact of inflation on essential commodities. It functions as a cost of living adjustment that safeguards workers' purchasing power against rising prices. This allowance is critical for low-wage workers, whose limited budgets are disproportionately affected by price increases in basic necessities. How often is it revised? It is revised biannually, once before April 1st and again before October 1st. This twice-yearly schedule ensures wage adjustments remain responsive to fluctuating economic conditions throughout the year. These fixed revision dates provide financial predictability for both employers and employees. Why is it revised? Regular revisions ensure workers' wages keep pace with the escalating costs of essential goods and services. Without periodic adjustments, inflation would steadily diminish the real value of workers' earnings, compromising their ability to maintain their living standards. Timely revisions help shield vulnerable worker populations from economic hardship during inflationary periods. What factors are considered during revision? Revisions analyze the cost fluctuations of essential commodities, including any subsidized rates available to workers. Consumer Price Index (CPI) metrics are examined to monitor changes in the cost of standard household necessities. Geographic variations in living expenses may be factored in to ensure equitable adjustments across different regions. Broader economic indicators, including inflation rates and market dynamics, inform the adjustment calculations. Who benefits from this revision? Minimum wage earners directly benefit from these systematic adjustments to their dearness allowance. Public sector employees and pensioners receive dearness allowance as an integral component of their compensation package. Workers across various industries covered by minimum wage legislation experience income adjustments based on these revisions. How is the revision amount calculated? Calculations are based on the average increase in the Consumer Price Index for industrial workers, CPIIW, over the designated period. A standardized formula converts index fluctuations into percentage increases that are applied to the base wage. Specialized committees review economic data and recommend precise adjustment rates based on comprehensive analysis. What is the historical importance of dearness allowance? This concept emerged during World War II, when unprecedented inflation necessitated wage supplements to sustain workers' purchasing power. It has since evolved into a fundamental component of wage structures across numerous employment systems. Dearness allowance represents a crucial economic safeguard that recognizes how macroeconomic shifts directly impact household financial stability. Normal working day: a standard 8-hour workday with mandatory break periods, confined to a maximum 12-hour spread, with special provisions for certain industries. Essential information about work hours, break entitlements, and special circumstances explained clearly. How long is a normal working day? A standard working day consists of 8 hours of actual work plus up to 1 hour of break time. This balance promotes both well-being and productivity. Can my workday be spread across many hours? No, your total workday including all breaks cannot exceed a 12-hour span on any given day. This limitation protects workers from fatigue and potential health complications. Are rest breaks included in my 8 working hours? No, the 8-hour period refers exclusively to actual work time. Rest breaks are additional time provided to ensure adequate rest, nourishment, and personal time during your shift. How many breaks am I entitled to during a normal working day? For a typical 8-hour shift, you should receive a main meal break of 30-60 minutes, plus shorter 10 to 15-minute breaks in the morning and afternoon for refreshment and rest. Can I choose when to take my breaks? While break schedules are typically determined by your employer to maintain workflow, reasonable flexibility should be provided for personal needs and urgent situations. Do these rules apply to agricultural workers? Agricultural work often follows modified regulations established by the central government, recognizing the unique seasonal demands and weather-dependent nature of farming work. What if I work in a factory? Factory employment falls under the Factories Act of 1948, which contains specific provisions addressing the particular working conditions, safety requirements, and operational needs in manufacturing settings. Are there special provisions for night shift workers? Yes, employees working night shifts typically receive additional compensation or benefits that acknowledge the disruption to natural sleep cycles and the potential health impacts of overnight work. What about overtime work beyond 8-hour? Work performed beyond the standard 8-hour day qualifies as overtime and must be compensated at premium rates, as specified by applicable labor laws or your employment agreement. For specific questions regarding your working hours or break entitlements, please consult your supervisor or HR department for guidance based on your particular role and the regulations governing your workplace. Weekly rest day. Common questions: workers are entitled to 1 weekly rest day, typically Sunday, with provisions for substitute rest days and appropriate compensation if work is required on rest days. Clear answers about your weekly rest day entitlements under labor regulations. When do I get my rest day? You're entitled to 1 rest day every week, traditionally Sunday. This rest day is earned after working for 6 consecutive days, ensuring a balanced work-rest cycle. What if my employer asks me to work on my rest day? If you work on your designated rest day, your employer must provide an alternative rest day within 5 days before or after your original rest day. This regulation prevents you from working more than 10 consecutive days without proper rest. How much will I be paid for working on my rest day? If you work on your rest day, you'll receive compensation at the same rate as your regular working day. However, if you're also given a substitute rest day, you'll receive overtime pay for the hours worked on your original rest day. Can my rest day be any day of the week? Absolutely. While Sunday is traditionally designated as the weekly rest day, your employer has the flexibility to assign any day of the week as your rest day, provided you receive 1 complete day of rest during each 7-day period. What constitutes a full rest day? A full rest day is defined as an uninterrupted 24-hour period, during which you have no work obligations. This continuous break ensures adequate time for personal activities, family commitments, and physical recovery. Do part-time workers also receive weekly rest days? Yes, part-time employees are equally entitled to weekly rest days. While the specific arrangements may be proportional to their work schedules, the fundamental right to 1 rest day per week remains applicable regardless of employment status. How are rest days handled with rotating shift schedules? For employees working rotating shifts, rest days may also follow a rotation pattern. Nevertheless, your employer must ensure you receive 1 full rest day for every 6 consecutive working days, maintaining proper work-rest balance. Are new employees on probation entitled to rest days? Yes, rest day provisions apply from your first day of employment, including during the probationary period. These are fundamental labor rights that aren't contingent on completing probation. Can my weekly rest day be divided into 2 half-days? No, your weekly rest day must be provided as a continuous 24-hour period. Splitting it into multiple shorter rest periods across different days does not fulfill the legal requirement for a proper weekly rest day. For additional information about your rest day entitlements or specific scenarios not covered here, please consult your company's HR department or review the details in your employment contract and company policy handbook. Night shifts. Frequently asked questions. Night shift workers receive rest days after their shift ends. Hours worked after midnight count toward the previous workday, and standard weekly rest periods apply despite unconventional schedules. Clear answers about managing work schedules that extend past midnight. What counts as a rest day for night shift workers? Your rest day is a continuous 24-hour period beginning when your shift ends. For example, if you finish at 6 a.m., your rest day runs from 6 a.m. until 6 a.m. the following day. How are workdays calculated for night shifts? Each workday is the 24-hour period starting when your shift begins, regardless of whether it crosses midnight. This ensures accurate tracking of work hours and rest periods. Which day do post-midnight hours count toward? Hours worked after midnight are counted as part of your previous workday. For instance, if you work 10 p.m. to 6 a.m., those 6 morning hours are considered part of the previous day's shift. Is there additional compensation for night shifts? Night shift compensation depends on your employment contract and company policy. Consult your HR department about night differentials or premium rates that may apply to your position. Can my employer schedule consecutive night shifts? Yes, but you remain entitled to your weekly rest day. Your employer must ensure you receive at least one 24-hour rest period weekly, even with rotating or consecutive night shifts. What break entitlements apply during night shifts? You're entitled to the same breaks as day shift workers for, typically at least 30 minutes for shifts exceeding 6 hours. Many employers provide additional short breaks during night shifts to maintain alertness and safety. Are there limits on consecutive night shifts? While regulations vary by jurisdiction, occupational health guidelines generally recommend limiting consecutive night shifts to 4/6 before providing an extended rest period. Check your employment contract for specific limitations. What if night work affects my health? If you experience health issues related to night work, consult your healthcare provider and notify your HR department promptly. You may qualify for workplace accommodations or schedule adjustments based on medical necessity. Do night shift workers receive the same public holidays? Yes, night shift workers are entitled to equivalent public holiday benefits. If a holiday falls on your scheduled workday, you should receive either compensatory time off or additional pay according to company policy. How can I optimize my sleep schedule for night shifts? Maintain consistent sleep timing even on days off. Create an optimal sleep environment with blackout curtains, white noise, and minimal disruptions. Limit caffeine intake before sleep, and consider exposure to bright light during your shift to regulate your circadian rhythm. For additional information about night shift policies specific to your role, please refer to your employee handbook or contact your HR representative. Frequently asked questions. Special working conditions. Special working conditions encompass 5 distinct scenarios: emergencies, preparatory tasks, intermittent duties, technical necessities, and nature-dependent work. These situations may operate under different rules than standard employment. Clear explanations of when special working rules apply to your employment. What is considered emergency work? Emergency work occurs during unexpected situations that couldn't have been predicted or prevented. This includes natural disasters, equipment failures threatening safety, or circumstances that could cause significant financial loss if not immediately addressed. During emergencies, standard working hour restrictions may be temporarily suspended. What counts as preparatory work? Preparatory work involves setup or finishing tasks that must occur outside normal working hours. This includes warming up machinery before production, conducting system checks before opening, or completing end-of-day paperwork. These essential activities enable normal business operations but fall outside standard shift times. What does intermittent work mean? Intermittent work involves natural periods of activity followed by waiting or inactivity. Examples include security guards, reception staff during quiet periods, or drivers between transport assignments. During inactive periods, you remain available but not actively working, which affects working hour calculations. What are technical requirements? Technical requirements apply when tasks must be completed for technical reasons before a shift ends. Examples include chemical processes that cannot be paused, concrete pours that must be finished, or software updates that cannot be interrupted. These situations may require adjustments to strict shift end times. What work depends on natural forces? Nature-dependent work can only be performed at specific times based on unpredictable natural events such as weather or tides. This includes agricultural harvesting, tide-dependent fishing operations, or weather-sensitive outdoor construction. These positions require scheduling flexibility beyond standard work arrangements. How are rest periods calculated under special working conditions? Even with special working conditions, employers must ensure appropriate rest periods. While timing and duration may differ from standard employment, the principle of adequate rest remains. When normal rest periods are disrupted, compensatory rest may be provided. Do special working conditions affect overtime calculations? Yes, special working conditions can modify overtime calculations and compensation. Hours worked under special conditions may have different overtime thresholds or compensation rates, depending on your employment contract and applicable regulations. Review your employment agreement for specific details. Can I refuse work under special working conditions? Your right to refuse work under special conditions depends on your employment contract, workplace health and safety regulations, and the reasonableness of the request. Some emergency situations may be mandatory, while others require consent. Consult your employment terms or union representative for clarification. If you're uncertain whether these special conditions apply to your situation, consult your supervisor or HR department for clarification based on your specific role and circumstances. FAQ: Special Working Categories. Key regulations include a maximum 16-hour workday span, 9-hour active work limit, and specialized provisions for unique job categories that accommodate various employment scenarios. Straightforward answers about time regulations for special working categories. How many hours can I be at work in one day? Your total workday span cannot exceed 16 hours from start to finish. This spread over time includes all hours from when you first begin until you complete your day, even if this includes significant break periods between active work. How many hours can I actively work in one day? You cannot perform more than 9 hours of actual work in a single day. This limit only counts time spent actively working and is designed to prevent excessive fatigue that might compromise your health and safety. Do rest breaks count as work time? No. Rest periods and standby time when you're on duty, but not actively working, don't count toward your 9-hour active work limit. However, brief breaks, 5 to 10 minutes, may be counted as work time based on your employer's specific policies. What are special working categories? These are specific job classifications with tailored time regulations, including emergency response work, preparatory activities, intermittent duties, technical operations, and jobs dependent on natural conditions. These categories recognize that certain occupations cannot reasonably follow conventional working patterns. Why do these special regulations exist? These provisions create a balance between worker protection and the practical requirements of jobs that cannot adhere to standard schedules. They safeguard workers from exploitation while providing necessary flexibility for industries with inherent scheduling challenges. Can my employer assign me to a special category without my agreement? Generally, your job classification should be clearly outlined during the hiring process. If your position naturally falls within a special working category, this should be specified in your employment contract. Any significant changes to your working conditions typically require proper notification and potentially your consent. Are there additional compensation rules for special working categories? Yes, many special working categories include enhanced compensation requirements such as overtime pay, special allowances, or compensatory time off. Your specific benefits depend on your job classification and applicable labor agreements. How do I determine which special category applies to my position? This information should be specified in your employment contract. If uncertain, consult with your HR department or supervisor to clarify your position's classification and the specific regulations governing your work schedule. Do weekly rest requirements apply to special working categories? Yes. Even within special working categories, you remain entitled to mandatory rest periods and weekly days off. However, the timing of these rest periods may differ from standard jobs to accommodate your work's specific nature. For additional questions about special working categories or clarification regarding your specific situation, please contact your HR representative or consult the Comprehensive Labor Regulations Handbook. Floor wage determination. Frequently asked questions. The central government establishes floor wages after consulting with the board and state governments. These wages can be revised every 5 years to reflect changing economic conditions. Here are answers to common questions about floor wage determination. Who determines the floor wage? The central government establishes the floor wage after mandatory consultation with the board and soliciting input from all state governments before finalizing their decision. What is the board's function in this process? The board provides expert recommendations to the central government regarding appropriate floor wage levels. These recommendations are then circulated to all state governments for further consultation. What role do state governments play? State governments have a consultative role in the process. The central government must obtain and consider feedback from all state governments before establishing the final floor wage rates. How frequently can floor wages be revised? Floor wages are typically revised on a 5-year cycle, though earlier revisions are permitted when economic circumstances warrant adjustments to maintain wage relevance. What criteria influence floor wage determination? Key considerations include geographical variations, required skill levels, work difficulty, and regional economic factors, for all of which help establish appropriate floor wage levels across different contexts. Can floor wages vary by region? Yes. Floor wages may be differentiated by geographic regions to accommodate varying living costs and economic conditions throughout the country. Is there a distinction between floor wage and minimum wage? Yes. The floor wage establishes a baseline threshold below which no minimum wage can be set. State governments retain authority to implement minimum wages exceeding the floor wage based on local economic conditions. How are significant economic changes addressed? While the standard revision interval is 5 years, the central government maintains authority to conduct earlier reviews and adjustments when substantial economic shifts significantly impact workers' cost of living. Are employers legally required to display floor wage information? Yes. Employers must prominently display all applicable wage information, including floor wages, in locations where workers can readily access and review this information. Payment of wages, deductions, frequently asked questions. Wage deductions cannot exceed 50% of monthly wages, with any excess carried forward. The Deputy Chief Labor Commissioner oversees these matters, and employers must display deduction notices prominently in the workplace. How much can be deducted from my wages in a month? The total deductions cannot exceed 50% of your monthly wages. If deductions would exceed this limit, the excess amount is carried forward to subsequent months. This 50% cap applies to all combined deductions, including statutory ones like Provident Fund contributions and income tax. What happens if my employer needs to deduct more than 50% of my wages? The excess amount will be recovered from your wages in future months. However, the monthly recovery still cannot exceed 50% of your wages in any given month. This protection ensures you always receive at least half of your earned wages, regardless of outstanding deductions. Who is the authority responsible for wage deduction matters? The Deputy Chief Labor Commissioner, central with jurisdiction over your workplace, handles wage deduction matters under Section 19(1). This authority reviews deduction-related cases and can issue binding orders regarding deduction disputes. Where can I find information about wage deductions at my workplace? Your employer must display wage deduction notices in clearly visible areas where all employees can easily read them. These notices should outline the circumstances under which deductions may occur and explain the process followed for making such deductions. What types of deductions are permitted from wages? Permitted deductions include statutory deductions, such as Provident Fund and income tax, payments for employer-provided amenities or services, recovery of advances or loans, deductions for damage to employer property, and contributions to welfare funds. Each category has specific guidelines governing implementation. Do I need to provide consent for wage deductions? Written consent is required for certain deductions such as welfare fund contributions or recovery for employer-provided services. However, statutory deductions mandated by law, like income tax, do not require your explicit consent. Is there a time limit for deductions related to damages or losses? Yes, deductions for damages or losses to employer property must be initiated within 90 days from when the damage or loss was determined. After this period expires, the employer cannot make deductions for that specific incident without special authorization. Important: your monthly wage deductions cannot exceed 50% under any circumstances. Any amount beyond this limit will be carried forward to future months. Wage deduction notices. Frequently asked questions: employers must display wage deduction notices prominently, notify labor inspectors, and follow proper approval protocols. These requirements ensure transparency and protect both parties from disputes while maintaining compliance with labor laws. Where should employers display wage deduction notices? Notices must be posted in highly visible locations throughout the workplace where all employees can easily read them. Strategic locations include notice boards in break rooms, near time clocks, entrance areas, and other high-traffic zones frequented by employees. Notices should be printed in clear, legible font and in languages understood by the workforce. Who else must employers notify about wage deductions? Employers must provide a copy of all deduction notices to the local inspector cum facilitator responsible for their workplace. This notification should be sent immediately after finalizing any decision to implement deductions. Complete records of these communications must be maintained for a minimum of 3 years for compliance purposes. What is the approval process for imposing fines? Employers must submit a detailed written request to the Deputy Chief Labor Commissioner, who will schedule a hearing for both parties to present their cases. The request must specify the nature of the offense, date of occurrence, proposed fine amount, and justification for the penalty. Employees have the right to representation and to present evidence in their defense during the hearing. The Commissioner will issue a binding written decision to both parties following the hearing. Why are these notification and approval requirements important? They establish transparency and fairness, protecting employees from arbitrary deductions while providing employers with clear procedures to follow. They create accountability and significantly reduce the potential for wage-related disputes and litigation. These requirements foster trust in the employer-employee relationship by establishing clear expectations and procedures. How long must deduction records be maintained? Employers must preserve comprehensive records of all wage deductions for at least 3 years. Records should detail the employee's name, deduction amount, reason, date, and references to any relevant approval documentation. All records must remain accessible for inspection by labor authorities upon request. Can employees challenge deductions they consider unfair? Employees have the right to contest any deductions they believe are unjustified or improperly implemented. The recommended first step is addressing concerns directly with their employer or HR department. If internal resolution fails, employees may file a formal complaint with the local labor office or inspector cum facilitator. Employees should maintain thorough documentation of all communications regarding disputed deductions. Deduction for damage or loss. Frequently asked questions. Employers must provide both verbal and written explanations of damages, allow employees to present their case, and issue written notification within 15 days of any wage deductions for damaged or lost goods. What steps must an employer take before making deductions? Employers must complete these 3 essential steps. Clearly explain the nature and extent of the damage or loss to the employee. Provide the employee with a fair opportunity to respond to the allegations. Issue formal notification within 15 days. If a wage deduction will be implemented, how must employers explain the damage or loss? The employer must communicate the issue through 2 channels. Verbally through a documented face-to-face discussion, in writing with comprehensive details about the damaged or lost items, with specific documentation of when, where, and how the damage occurred, including an accurate assessment of the damage or loss value. Can employees respond to the allegations? Yes. Before any deduction decision, employees must be given a fair opportunity to explain their perspective, including the right to present a detailed account of the incident, an opportunity to submit supporting evidence or witness statements, adequate preparation time to formulate their response, assurance of an unbiased hearing of their explanation. When will employees know if money is being deducted? If a deduction is determined necessary, the employer must notify the employee within 15 days of the decision. This notification must contain the precise deduction amount, a clear explanation of the justification for the deduction, transparent calculation methodology showing how the amount was determined, the specific pay periods, when the deduction will be applied. Is there a limit to how much can be deducted? Yes. Several protections exist to prevent excessive deductions. All deductions must be reasonable and directly proportional to the damage caused. Deduction amounts cannot exceed the actual verified value of the lost wages after deduction. Must remain at or above minimum wage requirements. Substantial deductions may need to be distributed across multiple pay periods. Can employees appeal against deductions they believe are unfair? Yes, employees have established rights to contest unjustified deductions. First, employees should initiate a formal discussion with their employer or HR department if the issue remains unresolved. Employees may file an official complaint with the local labor inspector. Employees should maintain thorough documentation of the incident and all related communications, because appeal deadlines may exist. Employees should initiate the process promptly. What records must employers maintain regarding deductions? Employers must keep detailed documentation of all deduction-related matters. Comprehensive incident reports detailing the damage or loss, copies of all written communications provided to the employee's formal statement or response to the allegations, detailed calculations demonstrating how the deduction amount was determined, evidence confirming proper and timely notification was provided to the employee. All records must be preserved for a minimum of 3 years. Recovery of advances. Employers may recover monetary advances from workers' wages, subject to protective limitations. Recovery is capped at 50% of wages per pay period, and employers must maintain detailed records of all transactions. Frequently asked questions: what qualifies as a recoverable advance? Any monetary payment provided to a worker after employment begins, or wages paid before they are earned. This includes cash advances for personal expenses, salary advances, and any other payments made to employees ahead of their scheduled payday. What are the limits on recovery amounts? Employers must recover advances in installments, with deductions limited to 50% of a worker's wages in any pay period. This restriction ensures workers maintain sufficient income for essential living expenses. What record keeping is required? Employers must document all advance recoveries in Form I records. These records must include the advance date, amount provided, installment amounts, recovery dates, and outstanding balance. Who determines the repayment schedule? The employer establishes the installment schedule, provided it adheres to the 50% maximum limit. The schedule should be reasonable and consider the worker's financial obligations and basic needs. Can advances be recovered as a lump sum? No. If recovery would exceed 50% of wages, it must be distributed across multiple installments in different pay periods. This provision protects workers from financial strain caused by excessive deductions. Are any payments exempt from recovery? Yes. Reimbursements for legitimate business expenses incurred by workers on the employer's behalf are not considered advances and cannot be recovered from wages. What happens to unpaid advances when employment ends? If employment terminates before full recovery of an advance, employers may deduct the remaining balance from final settlement payments, still subject to the 50% limitation. Can workers negotiate repayment terms? Workers may discuss alternative repayment arrangements with their employer, though the employer retains final authority over the schedule, provided it complies with the 50% maximum deduction rule. How does taxation apply to advance recoveries? The recovery itself is not a taxable event as it represents repayment of previously advanced funds. However, the wages from which these deductions are made remain subject to standard taxation requirements. Loans for housing and other purposes. Government-approved loans for housing and essential needs can be repaid through wage deductions, with both principal and interest recoverable according to central government guidelines. These provisions enable workers to access necessary financing while providing employers with a structured repayment framework. Frequently asked questions: what types of loans can be recovered from wages? Loans for housing construction and other purposes approved by the central government can be recovered through wage deductions. This includes housing construction loans, home improvement financing, and other essential purpose loans that meet government approval criteria. Can interest on these loans also be deducted from wages? Yes, both the principal amount and any accrued interest can be deducted from wages according to the terms specified in the government-approved loan agreement. Are there any limits on loan amounts or interest rates? Yes, the central government establishes limitations on loan amounts and permissible interest rates. These regulations protect workers from excessive debt while facilitating access to necessary financing. Limits typically vary based on income level, loan purpose, and prevailing economic policies. How are these loan deductions processed? Employers deduct portions of wages for loan repayment according to government guidelines. These deductions occur at regular intervals and are transferred directly to the lending institution. Employers must maintain accurate records of all deductions and include this information on wage statements. Do I need special approval for these loans? Yes, these deductions apply exclusively to loans approved by the central government for specific purposes. The approval process requires documentation regarding the loan purpose, income verification, and repayment capacity assessment to ensure compliance with established criteria. Is there a maximum percentage of wages that can be deducted for loan repayment? Yes, regulatory limits exist to prevent excessive deductions. While specific percentages may vary according to government regulations, these safeguards ensure workers retain sufficient income for essential needs after loan repayments. What documentation should employers maintain regarding loan deductions? Employers must maintain comprehensive records of all loan-related deductions, including loan amount, interest rate, payment schedule, and outstanding balance. These records must be available for inspection by labor authorities and accurately reflected in workers' wage statements. Can I request changes to my loan repayment schedule? Under certain circumstances, workers may request modifications to their repayment schedule. Such requests require approval from both the employer and the lending institution and must comply with government guidelines on loan repayment terms. Payment of bonus. Set-on and set-off companies can effectively manage bonus payment fluctuations across accounting years through two key mechanisms: carrying forward excess allocable surplus, set-on, or utilizing previous surpluses to cover current shortfalls, set-off. These provisions ensure stability in bonus allocations despite varying business performance. Frequently asked questions: what is set-on and set-off in bonus payments? Set-on refers to the process of carrying forward excess bonus allocation funds to future years, while set-off allows companies to address a current year's shortfall by utilizing surplus from previous accounting years. How does the set-on set-off mechanism work in the sixth accounting year? In the sixth accounting year, companies may either carry forward excess allocable surplus or compensate for a shortfall by utilizing the combined allocable surplus from both the fifth and sixth accounting years, providing greater flexibility. What provisions apply during the seventh accounting year? For the seventh accounting year, companies can leverage the cumulative allocable surplus from 3 consecutive years, fifth, sixth, and seventh, to manage any excess or deficiency in bonus payments, offering even more balancing options. Why are these set-on and set-off provisions beneficial? These provisions enable companies to maintain consistent and fair bonus payments over multiple years, effectively smoothing out the impact of business performance fluctuations and providing greater stability for both employers and employees. Are there limitations on set-on and set-off amounts? Yes, specific limitations apply. For set-on, companies can carry forward only up to 20% of the current year's allocable surplus. Similarly, for set-off, companies may utilize only up to 20% of the allocable surplus from previous qualifying years. Is implementing set-on and set-off optional for companies? No, these provisions are mandatory statutory requirements under the Payment of Bonus Act. All eligible companies must implement these mechanisms when calculating and distributing employee bonuses. How is the allocable surplus determined for set-on and set-off calculations? The allocable surplus is calculated as 60% of the available surplus for most companies and 67% specifically for banking companies. This allocable surplus serves as the foundation for all set-on and set-off calculations. Should companies inform employees about set-on and set-off adjustments? While not explicitly mandated by law, transparent communication regarding these adjustments fosters trust and helps employees better understand year-to-year variations in their bonus payments, promoting a positive workplace culture. What documentation requirements exist for these provisions? Companies must maintain comprehensive accounting records that clearly document all set-on and set-off amounts. These records must be readily available for examination during compliance audits conducted by labor authorities. A thorough understanding of these set-on and set-off mechanisms benefits both employers and employees by creating a balanced and equitable bonus payment system. This approach ensures long-term stability in bonus allocation while permitting necessary adjustments that reflect the company's actual financial performance over time. Computation of gross profits. FAQs. The Payment of Bonus Act provides distinct calculation methods for gross profits. Schedule B for banking companies, based on interest and commission income. Schedule C for non-banking companies, based on total income minus specified expenses, and Schedule D outlining prior charges deductible before determining bonus amounts. How do banking companies calculate gross profits? Banking companies must adhere to the methodology prescribed in Schedule B of the Act. They must aggregate all income derived from interest, commissions, and other banking services. From this total, they deduct expenses stipulated in the schedule, including interest paid on deposits, provident fund contributions, and maintenance costs. The calculation follows the formula: gross profit equals total interest and commission income, operational expenses plus deposit interest plus required reserves. For instance, if a bank earns 10 crores from interest and commissions, but incurs 6 crores in Schedule B expenses, their gross profit would amount to 4 crores. How do other types of companies calculate gross profits? Non-banking companies must comply with Schedule C of the Act. They begin with their aggregate income from all revenue streams, including sales of goods and services. From this amount, they deduct costs such as raw materials, services, and other expenses specified in the schedule. Deductible expenses encompass manufacturing costs, selling expenses, administrative overheads, and taxes, excluding income tax. For manufacturing entities, the formula typically reads, gross profit equals total sales, cost of goods sold plus operating expenses plus depreciation plus other Schedule C expenses. For example, if a manufacturing company generates sales of 50 crores and incurs Schedule C expenses of 40 crores, their gross profit would be 10 crores. What are prior charges in gross profit calculations? Prior charges constitute specific amounts that companies may deduct from their gross profits before calculating the bonus amount. These deductions are explicitly enumerated in Schedule D of the Act. They vary according to the company classification. Common prior charges include depreciation allowances, development rebates, direct taxes, and dividends payable on preference shares. Certain industries benefit from special provisions allowing additional prior charges specific to their sector. In capital-intensive industries, depreciation typically represents a substantial portion of prior charges. Why are there different methods for different companies? Different business models entail varying revenue streams and cost structures. Banking companies primarily generate income through interest and financial services, with distinct regulatory requirements and accounting practices. Other companies produce goods or provide alternative services, necessitating different approaches to calculating true profitability. The Act acknowledges these distinctions and prescribes appropriate calculation methodologies for each business category. These differentiated methods ensure equitable bonus calculations across diverse industries. The sector-specific approach is also aligned with other financial reporting and taxation requirements that vary by industry. How frequently must companies perform these calculations? Companies must calculate gross profits in accordance with the Act at the conclusion of each accounting year. The accounting year typically comprises a 12-month period aligned with a company's financial reporting cycle. Companies must maintain comprehensive records of all calculations to substantiate their bonus payment decisions. These records must remain accessible for inspection by authorized government officials when required. Can companies modify these calculation methods? No. Companies must rigorously adhere to the methods prescribed in the respective schedules of the Act. Any deviation from the specified calculation methodologies may result in non-compliance penalties. If a company falls under multiple categories, consultation with appropriate authorities is necessary to determine the applicable schedule. Where the Act provides no specific guidance on particular items, standard accounting principles and practices should govern. Allocable surplus management, frequently asked questions. Regulatory framework for managing excess or shortfall in bonus payment funds, allowing companies to carry forward surpluses or deficits for a statutory period of up to 4 years. What happens if there is excess allocable surplus available for bonuses? When allocable surplus exceeds the amount required for maximum bonus payments, the excess is carried forward to the subsequent accounting year. The carry-forward amount is capped at 20% of the total salary or wage bill for that accounting year. This surplus can be utilized for bonus calculations for up to 4 consecutive accounting years. Companies must maintain detailed accounting records documenting these surplus amounts in their financial statements. The carried forward surplus is legally reserved exclusively for employee bonus payments and cannot be repurposed for other expenditures. What happens if there is insufficient allocable surplus for minimum bonuses? In cases where allocable surplus is insufficient or non-existent for meeting minimum bonus obligations, the deficit is documented and can be offset in future profitable years. This shortfall can be carried forward and adjusted for up to 4 consecutive accounting years. Organizations must precisely record the deficit amount in their audited financial records. When profitability returns, addressing previously recorded shortfalls takes precedence before declaring new surplus amounts. Companies have a statutory obligation to disclose carried forward deficits to employees through appropriate communication channels. Why are these carry forward provisions significant? They enable organizations to effectively manage their statutory bonus obligations across multiple financial cycles. They safeguard employee interests by ensuring eventual disbursement of entitled bonuses despite temporary financial constraints. They establish an equitable regulatory framework that balances the interests of both employers and employees. They promote financial stability by allowing businesses to normalize bonus payments throughout economic fluctuations. They protect business continuity by preventing potentially destabilizing large one-time payments during recovery periods. How is the initial allocable surplus calculated? Allocable surplus is statutorily defined as 60% of the available surplus as determined under the Payment of Bonus Act. Available surplus is calculated by deducting depreciation, development rebate, direct taxes, and other prescribed items from gross profits. Banking institutions follow differentiated calculation methodologies as specified in Schedule B of the Act. The calculation process must be transparent and subject to review by authorized employee representatives upon request. Are there any exceptions to these carry-forward regulations? Newly incorporated companies may qualify for special provisions during their initial establishment period. Organizations undergoing substantial corporate restructuring may apply for specific regulatory considerations. Certain industry sectors with pronounced seasonal business patterns may operate under modified regulatory frameworks. All exemptions require proper documentation and validation by the appropriate regulatory authorities. Central Advisory Board composition. The Central Advisory Board comprises 12 employer representatives, 12 worker representatives, 10 independent members, and 5 state government representatives to ensure balanced stakeholder input in labor policy formulation and implementation. Frequently asked questions. Who sits on the Central Advisory Board? The board consists of representatives from 4 key stakeholder groups: employers, workers, independent experts, and state governments. This diverse composition ensures comprehensive consideration of all perspectives in labor policy development. The balanced representation prevents any particular interest group from exerting disproportionate influence on deliberations. Members serve defined terms, facilitating periodic renewal of perspectives and expertise. How many employer representatives are on the board? 12 members represent employer interests on the board. These representatives provide critical insights into business operations, challenges, and requirements. They are nominated by established industry associations and chambers of commerce. Employer representatives span various industry sectors to ensure comprehensive coverage of business perspectives. How many employee representatives are included? 12 members represent employee interests on the board. They advocate for workers' rights and welfare during policy discussions. These representatives are nominated by recognized trade unions and worker organizations. They contribute essential ground-level insights regarding workplace conditions and employee concerns. Who are the independent members on the board? Independent members include the board chairperson, 2 members of parliament, 4 professional experts, 1 industrial tribunal judge, and 2 state advisory board chairpersons. The chairperson facilitates proceedings and ensures balanced, productive discussions. Professional experts typically possess specialized knowledge in labor law, economics, or industrial relations. Members of parliament contribute legislative context and political considerations to labor policy discussions.
Do state governments have representatives too? Yes. 5 representatives from different state governments serve on the board, providing essential regional perspectives. These representatives are typically senior officials from state labor departments with substantial policy experience. They articulate how national labor policies might impact different geographical regions and local economies. A rotation system ensures equitable representation across states over time. How does the board make decisions? Decisions primarily emerge through consensus after thorough consultation with all stakeholder groups. When formal voting becomes necessary, each member holds equal voting power regardless of their representative category. The board's recommendations significantly influence national labor policy development and implementation. How often does the board meet? The Central Advisory Board convenes quarterly, with additional sessions scheduled when urgent matters require immediate attention. Specialized subcommittees may meet more frequently to address specific technical issues or concerns. This carefully balanced representation framework ensures the development of equitable and practical labor policies that address the legitimate concerns of all stakeholders. The board's diverse composition enhances the credibility and effectiveness of labor regulations by integrating multiple informed perspectives from across India's employment landscape. Gender balance in the board. Frequently asked questions. The board maintains specific composition requirements including 1/3 women members and a cap on independent members to ensure diverse representation in labor policy decisions. Key questions about board composition requirements. How many women must serve on the board? 1/3 of all board members must be women. For instance, in a 30-member board, at least 10 must be women. This requirement applies across all categories for employer representatives, worker representatives, independent members, and state government representatives. Is there a limit on independent members? Yes. Independent members cannot exceed 1/3 of the total board membership. In a 30-member board, no more than 10 can be independent members. This limitation ensures that employer and worker voices remain prominent in all discussions. Why are these balance requirements essential? These provisions ensure diverse perspectives in decision-making. Gender balance brings varied viewpoints, while limiting independent members maintains equilibrium between different stakeholder groups. This diversity results in more comprehensive and equitable labor policies. Who qualifies as an independent member? Independent members include the chairperson, members of parliament, professional members, industrial tribunal officers, and state advisory board chairpersons. These individuals provide objective expertise without representing specific employer or worker interests. What happens if the gender balance requirement isn't fulfilled? If the 1/3 women requirement isn't met, additional appointments must be made to achieve the required balance. The government must ensure compliance with this statutory requirement before the board can be properly constituted. Can the composition requirements be modified? Modifying composition requirements would require an amendment to labor legislation. Current requirements are established by law to guarantee fairness and diversity in representation. How are women representatives selected for the board? Women representatives are nominated from each stakeholder group. For employer and worker positions, relevant organizations nominate qualified women candidates. For independent and state government positions, women with appropriate expertise are selected through official channels. Do these balance requirements apply to state-level advisory boards? Yes. Similar balance requirements generally apply to state-level advisory boards, with some variations based on local legislation. The principle of diverse representation is maintained throughout the entire system. These carefully designed requirements create a balanced board that represents diverse groups and perspectives in labor policy development. This thoughtful composition ensures that policies benefit from multiple viewpoints and address the needs of all stakeholders, including women workers who often face unique workplace challenges. Common questions about the board's advisory role. The board serves in an advisory capacity to the central government, providing expert recommendations on minimum wages for working journalists and sales promotion employees, while final policy decisions remain with the government. Here are clear answers to frequently asked questions about the board's key advisory functions. What role does the board play regarding working journalists? The board advises the central government on fair minimum wages for working journalists employed by newspapers as defined in the Working Journalists Act of 1955. The board carefully evaluates industry standards, cost of living indices, and other relevant economic factors to ensure journalists receive appropriate compensation for their professional work. How does the board assist with sales promotion employees? The board provides expert guidance to the central government on establishing appropriate minimum wages for sales promotion employees as defined in the Sales Promotion Employees Act of 1976. Before making recommendations, the board conducts comprehensive reviews of market conditions, specific job responsibilities, and prevailing economic factors affecting this category of workers. Is the board's role only advisory or can it make final decisions? The board functions purely in an advisory capacity. While it provides well-researched guidance based on stakeholder consultation and thorough analysis, the central government retains final decision-making authority on minimum wage policies. The board's recommendations serve as a crucial input in the government's policy formation process. How does the board gather information for its recommendations? The board employs a systematic research approach, collecting data from diverse sources including industry reports, economic indicators, and extensive stakeholder consultations. It organizes focused meetings with employer associations, worker representatives, and industry experts to gain comprehensive insights into real-world conditions before formulating evidence-based recommendations. How often does the board review and update its wage recommendations? The board conducts periodic reviews of minimum wage recommendations typically every few years or when significant economic shifts impact living costs. Additionally, the board undertakes special reviews at the central government's request to address emerging sector-specific challenges or opportunities that may warrant wage policy adjustments. What factors does the board consider when making wage recommendations? The board applies a multifaceted analysis considering current economic conditions, inflation trends, industry profitability metrics, regional cost of living variations, required skill levels, and comparable wages in similar sectors. This comprehensive evaluation ensures recommendations balance fairness for workers with long-term sustainability for employers across diverse economic environments. Board meeting procedures. Frequently asked questions. Comprehensive guidance on board meeting protocols explained in accessible language. This document provides critical information regarding meeting convocation authority, notification requirements, attendance policies, and decision-making processes. Who can call a board meeting? The chairperson has the authority to convene meetings whenever deemed necessary. Additionally, upon receiving a written request from at least half of the board members, the chairperson must schedule a meeting within 30 days. Such requests must clearly articulate the meeting's purpose and specific agenda items for discussion. How much notice is given before meetings? For regular meetings, members receive notification at least 15 days in advance. This notice specifies the date, time, location, and agenda, delivered via both registered post and email. For urgent matters requiring immediate attention, members receive a minimum of 7 days notice. The secretary bears responsibility for ensuring all members receive proper and timely notification. How many members must attend for a valid meeting? A quorum requires attendance by at least 1/3 of total membership, including a minimum of 1 employer representative and 1 employee representative. If quorum requirements are not met, the meeting is adjourned and typically rescheduled within the following 14 days to ensure proper representation. How are decisions made during meetings? Decisions require approval by a simple majority, meaning more than half of attending members must vote in favor. In the event of a tied vote, the chairperson exercises a casting vote to resolve the deadlock. All voting outcomes are meticulously documented in the official meeting minutes. What happens if a member cannot attend in person? Members unable to attend physically may participate remotely through video conferencing with prior approval from the chairperson. Such participants count toward the quorum requirement and retain full voting privileges. Under exceptional circumstances, members may also submit written opinions on agenda items prior to the meeting for consideration. How are meeting minutes handled? The secretary maintains comprehensive minutes documenting attendance, substantial discussion points, and all decisions reached. Draft minutes are distributed to all members within 14 days following the meeting. Members then have a 7-day window to propose amendments before the chairperson finalizes and approves the official record. Can items not on the agenda be discussed? Meetings primarily adhere to the pre-circulated agenda. However, with the chairperson's discretion and time permitting, urgent matters may be introduced under any other business. For substantive new topics requiring thorough examination, the chairperson typically defers discussion to subsequent meetings, allowing members adequate preparation time. Frequently asked questions. Board member terms. Board members serve 2-year terms with possible extensions, can be replaced if they depart early, and serve at the government's discretion with removal possible when necessary. This guide explains term lengths, replacement procedures, and service conditions. How long do board members normally serve? Board members typically serve for 2 years from their appointment date. They may continue in their role until a replacement is appointed, even after their 2-year term ends. This ensures continuous board oversight during transition periods. What happens if a member leaves before their term ends? If an independent member departs early, through resignation, health issues, or other reasons, a replacement is appointed to complete only the remaining time of the original 2-year term. This maintains the board's staggered appointment schedule. How long do official members serve on the board? Official members, government representatives, remain on the board until another official is designated to replace them. Their term is linked to their government position rather than a fixed time period. This ensures continuous representation from essential government departments regardless of personnel changes. Can the government remove board members before their term ends? Yes. All board members serve at the pleasure of the central government, meaning the government can replace any member at any time if necessary. This allows the government flexibility to make changes when circumstances require new representation or when a member cannot fulfill their duties adequately. Can board members serve for more than 2 years? Yes. Members can remain in position beyond 2 years if their replacement hasn't been appointed. This ensures the board maintains sufficient membership to function properly. In exceptional circumstances, the government may extend a member's term beyond the standard 2 years if their expertise is particularly valuable. What qualifications must be maintained during a board member's term? Board members must maintain the same qualifications throughout their term that were required for their initial appointment. If a member no longer meets these qualifications, such as changing employment that affects their representative status, they may need to step down or be replaced. Are there attendance requirements for maintaining board membership? Yes. Board members must regularly attend meetings. If a member misses 3 consecutive meetings without obtaining leave of absence from the chairperson, they may forfeit their membership. This requirement ensures active participation from all members in the board's decision-making processes. Frequently asked questions. Board members support. Board members receive standardized travel allowances, comprehensive administrative support from senior government officials, and may serve a maximum of 2 consecutive terms. Clear answers to common questions about the allowances and support available to board members. What travel benefits do board members receive? Board members are entitled to travel and accommodation allowances when performing official duties, equivalent to those received by Group A officers in the central government. This package includes economy class airfare, hotel accommodations within prescribed limits, and daily allowances for meals and incidentals. All travel must receive prior approval and directly relate to official board functions. Who provides administrative support to the board? The central government assigns a senior official joint secretary level or above to serve as board secretary. Additionally, the government provides necessary staff to ensure smooth board operations. This support team typically comprises administrative assistants, research personnel, and technical experts as required. The secretary manages all administrative matters and functions as the primary liaison between the board and government departments. How long can someone serve on the board? Members may be renominated after completing their initial term. However, individuals are limited to a maximum of 2 terms total, with each term lasting 2 years. The maximum possible service period is 4 years. This limitation ensures the board benefits from fresh perspectives and broader representation over time. Are there any other benefits for board members? Beyond travel allowances and administrative support, the position primarily represents one of public service rather than financial compensation. Members receive reimbursement for reasonable expenses incurred while executing their duties, including communication costs and necessary office supplies. Some boards offer modest sitting fees for meeting attendance, though this varies according to board type and government regulations. What office facilities are available to board members? Members have access to fully equipped meeting facilities, dedicated office space during board sessions, and all communication tools necessary for their responsibilities. In certain situations, temporary workspace may be provided for members working on specific board projects or preparing for critical meetings. How are board members supported in their decision-making process? Members receive comprehensive briefing materials prior to meetings, access to relevant research and data, and may request additional information through the secretary. Subject matter experts can be invited to provide specialized knowledge when required, and members may participate in orientation or training sessions to enhance their effectiveness in their roles. What technological support is provided to board members? Depending on the board's specific functions, members may receive secure digital access to confidential documents, specialized software for reviewing materials, video conferencing capabilities for remote participation, and dedicated technical support staff to assist with technology-related challenges. Resignation and vacancy in the board members may resign by submitting written notice, with resignations taking effect within 30 days. The central government is responsible for appointing new members to fill vacancies in accordance with code provisions. Frequently asked questions FAQs. How can a board member resign? Members may resign by submitting a written notice to the chairperson. The notice must clearly state the intention to resign and include the member's signature and date. The chairperson may resign by submitting a formal letter to the central government through the designated ministry official. When does a resignation become effective? A resignation becomes effective either upon acceptance by the appropriate authority or after 30 days from submission, whichever occurs first. The member must continue fulfilling all duties during this transition period. What happens when a board position becomes vacant? The chairperson must notify the central government of any vacancy within 7 working days. The government will then initiate the process to fill the position according to code provisions. During this interim period, the remaining board members continue to function, provided quorum requirements are met. Can a member withdraw their resignation? The code does not explicitly address withdrawal of resignations. Once submitted, the resignation follows the established timeline. If a member wishes to continue serving, they must communicate this to the chairperson before the resignation becomes effective, though acceptance of such withdrawal remains at the discretion of the appointing authority, who is responsible for appointing new board members. The central government holds the authority and responsibility to fill board vacancies in accordance with code provisions. This includes adhering to established nomination procedures and ensuring all new appointees meet the eligibility requirements specified in the regulations. Is there a time limit for filling vacancies? While the code does not specify an exact time frame, the central government is expected to fill vacancies promptly to maintain the board's operational continuity. Prolonged vacancies that affect quorum may impair the board's ability to conduct valid meetings and make decisions. Does a replacement member serve a full term? Members appointed to fill midterm vacancies typically serve only for the remainder of the original term. This partial term may or may not count toward the 2-term maximum limit, depending on specific provisions in the governing regulations. Frequently asked questions. Board membership termination. Board membership can terminate through cessation, absence from 3 consecutive meetings, or disqualification, mental incapacity, insolvency, or criminal conviction. The central government maintains final authority on all disqualification determinations. How can board membership end? Board membership can terminate in 2 distinct ways: through cessation, failure to attend meetings, or disqualification, specific personal circumstances. Both processes are comprehensively outlined in the code to ensure the board maintains active participation and qualified membership. What is cessation of membership? A member automatically forfeits their position if they miss 3 consecutive meetings without providing prior notification to the chairperson. This provision ensures all board members maintain active engagement in governance and decision-making processes. The chairperson must document such absences in the official meeting minutes. What constitutes disqualification from board membership? An individual becomes ineligible for board membership if a court has declared them mentally incapacitated or unable to manage their affairs, they have been declared insolvent by a competent authority, they have been convicted of a crime involving moral turpitude or dishonesty that compromises board integrity, they hold positions in other organizations creating conflicts of interest, they no longer satisfy the eligibility requirements specified in their original appointment. Who determines disqualification? The central government retains exclusive authority to make final determinations regarding disqualification matters. The government conducts a thorough review of all pertinent evidence and documentation before rendering a decision. This determination is binding and must be implemented by the board without delay. Can a disqualified member appeal the decision? Yes. Disqualified members may submit an appeal to the designated appellate authority within 30 days of receiving the disqualification notice. The appeal must include all relevant facts and supporting documentation. During appellate proceedings, the member remains disqualified unless the appellate authority explicitly issues a stay order. What notification procedures exist for membership termination? For cessation cases, the chairperson must provide written notification to the member regarding their membership termination due to absence. In disqualification cases, the central government issues formal notifications to both the member and the board. All membership terminations require official documentation in board records and inclusion in the annual summary report. Is future reappointment possible for terminated members? Members who lost their position through cessation may become eligible for reappointment after a 1-year cooling period, subject to meeting all current eligibility criteria. However, individuals disqualified due to criminal conviction or insolvency typically face extended or permanent restrictions on reappointment, depending on the severity of the disqualifying circumstances and applicable legal provisions. Payment of dues after employee death. When an employee dies, employers must observe a 3-month waiting period before depositing unpaid wages with the Labor Commissioner, who will then verify and disburse payments to the employee's nominee within 2 months. Frequently asked questions: what happens to unpaid wages when an employee dies? Any outstanding compensation owed to the deceased employee is temporarily held before being disbursed to their designated nominee. This includes salary, bonuses, reimbursements, and any other compensation that remained unpaid at the time of death. How long must employers wait before processing these payments? Employers must observe a mandatory 3-month waiting period from the date the payment was due. This interval allows sufficient time for administrative processes and potential claims to be addressed before fund transfer. Where does the money go after the waiting period? After the waiting period, the employer must deposit the full amount with the Deputy Chief Labor Commissioner having jurisdiction in that area. This deposit must be accompanied by comprehensive documentation of the employee's service record, payment history, and nomination details. How long will it take for the nominee to receive the money? The Deputy Commissioner will complete verification of the nominee's identity and disburse payment within 2 months of receiving the deposit. This verification process encompasses confirming nomination documentation, validating the nominee's identity, and ensuring no competing claims exist. What if the employee's whereabouts are unknown? The identical process applies. Funds are retained for 3 months, then deposited with the Labor Commissioner. The Commissioner will subsequently undertake efforts to locate the employee or determine their status before proceeding further. What documentation should employers maintain during this process? Employers must maintain comprehensive records including the employee's complete service history, payment details, death certificate, nomination forms, and all correspondence pertaining to the deposit of dues. These records are essential for the verification process. Can the nominee be changed after the employee's death? No. Nominations become irrevocable upon the employee's death. The nominee officially designated by the employee during their period of employment remains the sole rightful recipient of any unpaid dues. What happens if there is no nominated beneficiary? In the absence of a designated nominee, the payment will be processed under the undisbursed dues without nomination protocol, which follows a distinct timeline and procedural framework for disbursement. Are there any tax implications for these payments? Payments to nominees may carry tax implications contingent upon the nature of the disbursement and prevailing tax regulations. Nominees are advised to consult qualified tax professionals regarding potential tax obligations on received amounts. Can employers expedite this process in cases of financial hardship? In circumstances of demonstrable financial hardship, nominees may submit a formal petition to the Labor Commissioner requesting expedited processing. While such requests require supporting documentation, approval remains at the Commissioner's discretion. Undisbursed dues without nomination. When an employee doesn't designate a nominee, their unpaid wages must be held for 6 months, then deposited with the Deputy Chief Labor Commissioner within 15 days. These funds are subsequently invested in government securities or placed in approved bank deposits. Frequently asked questions: what constitutes an undisbursed amount? Any compensation owed to an employee that remains unpaid because the employee didn't designate a nominee or for any other reason. What is the mandatory waiting period before employers take action? Employers must observe a 6-month waiting period from the date the payment was due before proceeding with the deposit process. Where must employers deposit these unpaid amounts? Following the 6-month waiting period, employers must transfer all unpaid amounts to the Deputy Chief Labor Commissioner with jurisdiction in that area. This transfer must occur within 15 days after the 6-month period concludes. How are these funds managed once deposited? The funds are actively managed through investment in government securities, central or state, or placement in fixed deposit accounts at authorized banking institutions. Who oversees the management of these investments? The Deputy Chief Labor Commissioner bears responsibility for ensuring proper investment of these funds and maintaining comprehensive records of all deposits. Can family members claim these amounts after deposit? Yes. Legitimate heirs or family members retain the right to claim these funds by submitting appropriate documentation that verifies their relationship to the deceased employee. What documentation is required for claim verification? Claimants typically need to provide government-issued identification, the employee's death certificate, relationship proof, such as marriage or birth certificates, and relevant legal documents like wills or succession certificates. Is there a deadline for submitting claims? While claims can be submitted after deposit, practical limitations exist as unclaimed wages may eventually transfer to government welfare programs after 7 years, as outlined in subsequent material. Do employers have notification obligations regarding undisbursed dues? Yes. Employers must inform the Labor Commissioner about the circumstances surrounding the undisbursed amounts and provide comprehensive employment details of the deceased or untraceable employee. Adherence to these procedures ensures that earned wages are properly safeguarded even when employees have not designated nominees, protecting both employer compliance requirements and the eventual distribution of funds to legitimate claimants. Frequently asked questions. Undisbursed wages. Workers can learn about unpaid wages through official notice boards and newspaper publications. File claims with the Deputy Chief Labor Commissioner, and should be aware that unclaimed wages may be allocated to government welfare initiatives after 7 years. Clear answers to common questions about the public notification and claim process for unpaid wages. How will workers be notified about undisbursed wages? The Deputy Chief Labor Commissioner will display comprehensive details about unpaid wages on notice boards for a minimum of 15 days. This information will also be published in 2 local newspapers in the regional language predominant in the area where the wages were earned. These notifications will include the employee's name, last known address, and the precise amount of unpaid wages. How can someone claim unpaid wages? If you are a nominee or legitimate heir entitled to unclaimed wages, you may submit a formal claim to the Deputy Chief Labor Commissioner. You will be granted an opportunity to present your case before any disbursement occurs. All claims must include valid identification documents, employment verification, and documentation establishing your relationship to the employee if claiming as a legal heir. What happens to wages that nobody claims? Wages remaining unclaimed for 7 years may be redirected by the central government toward worker welfare programs or other governmental initiatives. Once transferred to these programs, the original claimants generally forfeit their rights to recovery. Who is responsible for publishing the notice? The Deputy Chief Labor Commissioner bears full responsibility for both posting notice board announcements and coordinating newspaper publications regarding unclaimed wages. This official must ensure that all information is readily accessible and effectively communicated to potential claimants. What information will be included in the published notices? Notices will specify the employee's name, designation, last known address, employment period, exact amount of unpaid wages, and detailed instructions for claim submission. They may also include application deadlines and contact information for relevant authorities. Is there a time limit for filing claims? Yes. Claims must typically be submitted within the 7-year period before funds potentially transfer to government initiatives. While specific deadlines may vary, it is strongly recommended to file claims promptly upon discovering the existence of undisbursed wages. What documents are needed to file a claim? Essential documentation includes government-issued identification, employment verification, such as appointment letters or salary statements, death certificate of the employee, if applicable, and legal documents establishing your relationship to the employee when claiming as an heir or nominee. Supplementary evidence may strengthen your claim's validity. Can multiple people claim the same undisbursed wages? Yes. Multiple claims for identical wages may arise, particularly in cases without designated nominees. The Deputy Chief Labor Commissioner will conduct formal hearings to determine the legitimate claimant based on legal provisions and the comprehensive evidence provided by all parties. Important. Regularly monitor notice boards and local newspapers if you believe you may have outstanding wages from a former employer. Prompt action significantly enhances your prospects of successfully recovering your entitled compensation. If you require assistance with the claim process, consider consulting a specialized labor law advisor or legal aid organization that focuses on employment matters. Many provide complimentary or affordable services to workers seeking to recover unpaid wages. Common questions about forms and applications. Key forms for workplace procedures. Form I, record keeping. Form 2, applications. And Form 3, appeals. Each serves a specific purpose in the administrative process and must be completed according to guidelines specified in the code. Below are comprehensive answers to frequently asked questions about the forms required for applications, appeals, and record keeping under labor regulations. How do I file an application? Submit your application using Form 2, the standardized format for all application types. Include all required supporting documents as listed in the form. File your application in triplicate with a designated authority specified in the notification. Be prepared to provide additional information if your application is considered incomplete. Maintain copies of your application and all attachments for your personal records. What if I disagree with the authority's decision? You may appeal against an authority's order within 30 days of receiving it. Submit your appeal using Form 3 to the designated appellate authority in your jurisdiction. Attach all reference documents as evidence to support your case. Clearly articulate the specific grounds on which you're challenging the decision. The appellate authority may grant an extension of up to 60 days for filing an appeal if you demonstrate sufficient cause for the delay. What records must employers keep about fines and deductions? Employers must document all fines in a register using Form I. This same form must track all wage deductions and any funds collected through these deductions. Maintain this register for at least 3 years from the date of the final entry. Make entries chronologically without leaving blank spaces to preserve record integrity. Keep the Form I register accessible for inspection by authorized officials during reasonable hours. Electronic records are acceptable provided they follow the prescribed format and remain easily accessible for verification. Which forms do I need for different purposes? Form I. Employers use this to record fines and deductions from workers' wages, ensuring transparency in employee compensation. Form 2. The primary form for filing applications related to matters requiring official approval or consideration under the code. Form 3. Used for appealing decisions or orders issued by authorities, allowing reconsideration of unfavorable determinations. Form IV. For maintaining comprehensive employee information including designation, working hours, and leave records. Form V. For wage slips that provide employees with a detailed breakdown of earnings and deductions. Note: complete all forms in either the regional language of your area or in English. Incomplete submissions may cause processing delays or rejection. Assistance with completing these forms is available at your district's labor welfare centers. Wage slip and register requirements. Employers must maintain specific registers and provide wage slips to workers. These requirements ensure transparency in wage payments and provide essential documentation for both parties. What records must employers keep? Employers must maintain two types of registers under the code. Form I register for documenting wages and deductions. Form IV register for comprehensive employee information. These registers may be maintained either physically or electronically. The Form I register must include detailed entries for complete wage calculations and payment dates, overtime hours worked and corresponding compensation, any fines imposed with clear justification, or deductions made for damages, losses, or other authorized reasons. The Form IV register must contain employee personal details including name, designation, and identification number, employment commencement date and contractual terms, leave entitlement, utilization, and attendance records, job classification and skill category specifications. When must wage slips be provided to workers? Employers must issue wage slips to all employees on or before the payment date. These wage slips must strictly adhere to Format V as specified in the code. Wage slips are mandatory regardless of whether payment occurs weekly, fortnightly, or monthly. Upon request, employers must provide clear explanations for any unusual deductions appearing on the wage slip. Workers should preserve these wage slips as payment evidence for a minimum of 3 years. Can registers and wage slips be digital? Yes. Current legislation permits employers to maintain all records either electronically or in physical format. Similarly, wage slips may be distributed to workers either as physical documents or through digital means. Digital records must be maintained with appropriate security measures and backed up regularly, readily accessible to authorized inspectors upon request, safeguarded against unauthorized alterations, retrievable in a legible format throughout the mandatory retention period. Many employers now utilize specialized payroll software that automatically generates compliant wage slips and maintains the required registers. Why is this important for workers? These regulations ensure workers understand exactly how their wages are calculated and what deductions are applied. Proper record keeping protects both employees and employers in the event of payment disputes. Transparent wage documentation enables workers to verify receipt of all entitled payments, including overtime compensation and performance bonuses. Confirm that all deductions are legitimate and within prescribed legal limits. Maintain reliable proof of employment and income for financial applications. Submit accurate tax returns with appropriate supporting documentation for migrant and contract workers. Comprehensive documentation is particularly vital as it establishes their formal employment status and associated entitlements. What are the penalties for non-compliance? Employers who fail to maintain proper registers or provide wage slips may face substantial financial penalties as specified in the code. Mandatory corrective actions under regulatory supervision, enhanced scrutiny during subsequent labor inspections, potential legal proceedings. If violations persist, workers can report non-compliance to labor authorities without fear of retaliation, as whistleblower protections apply. Common questions. Inquiry procedure for offenses. An overview of how violations are reported, investigated, and resolved through a formal hearing process under the code. Here are answers to frequently asked questions about how offenses are investigated under the code. How is a complaint filed? Complaints may be submitted by aggrieved employees, registered trade unions, government inspectors, or any authorized officer. All complaints must be filed with the designated officer under Section 53(1) of the code. The submission should include comprehensive details about the alleged violation, specifying dates, times, locations, and the precise nature of the offense. What happens after a complaint is filed? The officer conducts a preliminary assessment to determine if a potential code violation exists. If sufficient evidence is found, they will issue a formal summons to the accused party, clearly stating the alleged offense, relevant code section, and scheduled hearing date. How does the hearing work? The hearing begins with the accused's opportunity to admit or deny the allegations. If guilt is admitted, the officer proceeds directly to penalty determination. If denied, a formal evidence presentation process follows, where witnesses provide sworn testimony subject to cross-examination by both parties. All statements are officially recorded, and documentary evidence may be submitted to support either position. How is the final decision made? The officer evaluates all testimony and evidence presented during the hearing, applying the relevant provisions of the code to reach a determination. This decision, which concludes the inquiry process, is documented and formally communicated to all involved parties. Can I bring legal representation to the hearing? Yes. Both complainants and respondents are entitled to legal representation throughout the hearing process. Legal counsel may present arguments, examine witnesses, and ensure your procedural rights are protected. Is there a time limit for filing complaints? Yes. The code stipulates specific limitation periods for filing complaints, which vary according to the nature of the offense. While these timeframes are strictly enforced, it is always advisable to report violations promptly to preserve evidence and witness recollections. What if I disagree with the officer's decision? Parties dissatisfied with the ruling may file an appeal to the designated appellate authority as specified in the code. Such appeals must typically be submitted within 30 days of receiving the written decision, along with grounds for contesting the original determination. Are the hearings public or private? To maintain confidentiality and protect the interests of all parties, hearings are conducted in private settings. Attendance is restricted to those with direct involvement in the case, including the parties, their representatives, and witnesses when testifying. Composition of offenses. Composition allows eligible offenders to pay 50% of the maximum penalty to settle cases without a trial. Applications must be submitted via Form 6 to an appointed gazetted officer who determines eligibility and processes the settlement. Frequently asked questions. What is composition of offenses? A legal mechanism that allows eligible offenders to settle cases by paying a reduced fine, 50% of the maximum penalty, instead of undergoing a full trial. This streamlined process reduces court congestion while offering a simplified resolution pathway. How do I apply for composition? Submit an application in Form 6 to the designated gazetted officer. Include details of the alleged offense, your contact information, and a clear statement of your willingness to pay the composition amount. Which offenses qualify for composition? Not all offenses are eligible. The gazetted officer evaluates each case against criteria in the code. Generally, serious violations, repeat offenses, or those with significant public impact may not qualify for composition. What is the payment amount? For eligible offenses, the composition fee is exactly 50% of the maximum fine applicable to your offense. The gazetted officer will calculate and formally communicate this amount in the composition order. What happens after payment? Once payment is processed, your case is considered fully settled. If legal proceedings were already initiated, the officer will notify the relevant authorities to close the matter. This acts as a complete settlement of your liability for that specific offense. Is there a deadline for applying? Yes. While the code may not specify an exact time frame, it's advisable to apply promptly after receiving notice of the offense. Delays may affect eligibility, particularly if court proceedings have substantially progressed. Does a composed offense affect my record? Though the case is settled, authorities maintain records of the composition. This information may be considered in the assessment of any future violations, potentially affecting eligibility for composition in subsequent cases. Can I challenge a composition rejection? The gazetted officer's determination regarding composition eligibility is generally considered final under the code. However, you may pursue standard legal remedies if you believe the decision contravenes established guidelines. Should I consult a lawyer before applying? While not required, professional legal consultation is advisable. A lawyer can assess whether composition serves your best interests and help navigate the application process to maximize the likelihood of a favorable outcome. Timely payment of wages. Legal provisions ensuring workers hired through contractors receive timely compensation by mandating establishments to finance contractors before scheduled payment dates. Frequently asked questions. Who is responsible for paying workers hired through contractors? The establishment owner, company, firm, or individual must transfer funds to the contractor before the wage payment date. This ensures contractors have sufficient resources to compensate workers on time. Why does the law require payments to contractors in advance? This requirement enforces compliance with Section 17, which guarantees timely wage payments. By funding contractors in advance, the law prevents payment delays and protects workers' financial security. What is the legal definition of firm in this context? The term firm carries the same definition as established in the Indian Partnership Act of 1932, encompassing all business partnerships officially registered under Indian law. What are the consequences if an establishment fails to pay the contractor on time? Establishments failing to transfer funds to contractors before the wage payment date violate these regulations and may face legal penalties for non-compliance with wage payment laws. What is the required time frame for establishments to pay contractors? The law mandates that establishments transfer funds to contractors sufficiently in advance of the wage payment date. While specific timeframes vary by circumstance, the transfer must allow adequate processing time to ensure workers receive timely payment. Are there exceptions to these payment regulations? The legislation provides no general exemptions regarding timely wage payments. All establishments employing contract workers must adhere to these provisions to safeguard workers' right to timely compensation. What records should be maintained regarding these payments? Both establishments and contractors must maintain comprehensive documentation of all fund transfers, including dates, amounts, and worker details. These records serve as compliance evidence during inspections and are essential for resolving potential disputes. What recourse do workers have if they don't receive timely wages? Workers can file formal complaints with labor authorities if they experience payment delays. The law provides multiple redress mechanisms, including approaching labor inspectors or submitting formal grievances under wage payment regulations. How do these provisions complement other wage protection laws? These regulations specifically address the contractor-establishment relationship within the broader framework of wage protection legislation. They ensure that subcontracting arrangements cannot undermine workers' fundamental right to timely compensation. Technical Advisory Committee for Working Journalists, FAQs, a specialized committee appointed by the central government to determine fair minimum wages for journalists and provide evidence-based recommendations that reflect industry standards. Key questions about the committee responsible for establishing minimum wages for journalists. What is the Technical Advisory Committee? A specialized body established by the central government to determine fair minimum wages for journalists. The committee comprises experts in labor economics and journalism who provide informed recommendations to ensure appropriate compensation standards within the industry. Who qualifies as a working journalist? As defined in the Working Journalist and Other Newspaper Employees Act of 1955, a working journalist includes professionals who write, edit, or create news content for newspapers and news organizations. This encompasses reporters, editors, photographers, and content creators employed by news outlets, but excludes administrative staff and printing press operators. How does the committee operate? Appointed under Section 8 of the Code, the committee conducts comprehensive assessments of journalist working conditions and industry standards before recommending appropriate minimum wage levels. Their methodology includes analyzing regional wage variations, cost of living data, interviewing stakeholders, and evaluating the financial health of news organizations. Why is this committee essential? The committee safeguards journalists' interests by establishing fair compensation that reflects their professional skills and responsibilities. In today's evolving media landscape with increasing economic pressures on news organizations, the committee plays a vital role in balancing equitable compensation with industry sustainability. How frequently are wage standards reviewed? The committee conducts reviews every 3-5 years or as directed by the central government to ensure wage recommendations remain aligned with current economic conditions and industry developments. Special reviews may be initiated following significant shifts in the media landscape. Can news organizations dispute the committee's recommendations? News organizations may present concerns through industry associations during the committee's consultation phase. Once the central government formalizes the recommendations, organizations must comply with established minimum wages, though they may pursue legal appeals if they believe exceptional circumstances warrant exemptions. Does the committee account for regional cost variations? Yes. The Technical Advisory Committee factors in geographic differences in living costs when formulating recommendations. They may propose tiered minimum wage structures for journalists working in metropolitan areas versus those in smaller towns and rural regions, acknowledging the substantial variations in living expenses across different locations. When contractors fail to pay mandatory bonuses, workers can report this violation, and after proper verification, the principal employer becomes legally responsible for disbursing these payments under Section 43 of the Code. Questions about bonus payment responsibility. Common questions regarding bonus payment obligations when contractors default. Who is responsible if a contractor doesn't pay the minimum bonus? When a contractor fails to pay the minimum bonus required by Section 26, the principal employer assumes responsibility for making these payments to the affected workers. This safeguard ensures workers receive their legally entitled bonuses regardless of contractor negligence. How do workers report unpaid bonuses? Workers can report unpaid bonuses by submitting written notification about the default either directly to the principal employer or through a registered trade union. The complaint should include essential details such as employment period, bonus amount due, and contractor information. Does the company pay immediately after receiving a complaint? No. The principal employer first conducts a verification process to confirm the contractor's failure to pay the required bonus. Payment is made only after this verification is complete, balancing the need to address legitimate claims while preventing fraudulent reports. What legal section covers this responsibility? This responsibility is established under the proviso to Section 43 of the Code, which was specifically implemented to protect the financial entitlements of contract workers by ensuring bonus payments even when contractors default. Is there a time limit for reporting unpaid bonuses? Yes. Workers should report unpaid bonuses within a reasonable time frame, typically within the same financial year or according to company policy guidelines. Prompt reporting facilitates easier verification and timely resolution of payment issues. Can the principal employer recover these payments from the contractor? Yes. After disbursing bonus payments to workers on behalf of the defaulting contractor, the principal employer is entitled to recover these amounts through legal recourse or by adjusting future payments to the contractor. Does this apply to all types of contract workers? This provision applies universally to all contract workers who qualify for bonuses under Section 26 of the Code, regardless of their specific job function or industry sector, provided they meet the established eligibility criteria for bonus entitlements. The inspection scheme is a government-approved framework that systematizes workplace inspections through unique identification numbers for both inspectors and workplaces, ensuring complete transparency and accountability. Inspection scheme frequently asked questions. Essential questions about the implementation and management of workplace inspections. What is the inspection scheme? A comprehensive plan developed by the Chief Labor Commissioner with government approval that standardizes workplace inspection procedures and protocols. Who establishes this scheme? The Chief Labor Commissioner Central develops the scheme, which must receive formal approval from the central government before implementation. What key elements does the scheme include? The scheme assigns unique identification numbers to each authorized inspector and each workplace subject to inspection, creating a trackable system. Why are identification numbers necessary? These unique identifiers enable efficient tracking of inspections, facilitate accurate record keeping, and enhance transparency throughout the entire inspection process. How are workplaces selected for inspection? Selection occurs through an impartial computerized system that randomly identifies workplaces based on risk assessment profiles and previous compliance history, ensuring objectivity and fairness. Are employers notified about upcoming inspections? Typically, inspection schedules remain confidential to ensure inspectors can observe authentic workplace conditions without allowing for special preparations that might mask violations. What documentation must employers maintain for inspections? Employers must keep current and accurate registers related to wages, attendance, overtime, and other labor compliance matters, and make these readily accessible during inspections. What authority do inspectors have during site visits? Inspectors are empowered to enter premises during operational hours, review records, collect statements from workers, and gather evidence pertaining to labor law compliance. What recourse exists for businesses concerned about improper inspections? Businesses can file formal complaints regarding inspector conduct with the Regional Labor Commissioner's office, specifically referencing the inspector's unique identification number assigned under the scheme. This methodical approach to workplace inspections ensures equitable enforcement of labor laws while minimizing disruption to legitimate business operations and promoting a culture of compliance. Schedule A. Common questions about set-on and set-off. The set-on and set-off mechanism enables companies to strategically allocate bonus funds by carrying forward surplus from profitable years to support payments during lean periods, ensuring consistent and equitable bonus distribution for employees across multiple financial cycles. Essential information about how the set-on and set-off mechanism regulates bonus calculations over multiple years. What is the set-on and set-off mechanism? A systematic approach that allows companies to reserve excess bonus allocations from profitable years to supplement bonus payments during challenging financial periods, creating stability in employee compensation despite profit fluctuations. Where is this mechanism established in law? Section 15 of the Payment of Bonus Act explicitly outlines the set-on and set-off provisions, establishing the regulatory framework for allocating and carrying forward surplus funds designated for bonuses. What constitutes allocable surplus? Allocable surplus represents the designated portion of a company's profits available for employee bonuses, calculated as a specified percentage of gross profits after statutory deductions. How was the calculation applied in year 1? In year 1, the company generated 104,167 rupees in allocable surplus, distributing the entire amount to employees with no carry-forward balance, representing full utilization of available bonus funds. What occurred in year 2? Year 2 produced 635,000 rupees in allocable surplus, with only 250,000 rupees distributed as bonuses. The company implemented the set-on provision for the remaining 385,000 rupees, reserving these funds for future bonus disbursements. How was bonus distribution managed in year 3? In year 3, the company had 220,000 rupees in allocable surplus but distributed 250,000 rupees to employees by supplementing with 30,000 rupees from the previous year's set-on reserve, leaving 355,000 rupees in the reserve account. What transpired in year 4? Year 4 generated only 100,000 rupees in allocable surplus. To maintain consistent bonus levels, the company utilized 150,000 rupees from the set-on reserve, enabling a total distribution of 250,000 rupees while reducing the reserve to 205,000 rupees. How does the mechanism function during loss-making periods? During years with losses or insufficient profits, the set-off component becomes operational, allowing companies to utilize previously reserved set-on amounts to sustain employee bonus payments despite financial challenges. Are there temporal limitations for utilizing set-on reserves? Yes. Reserved set-on amounts must typically be utilized within statutorily prescribed time frames, ensuring that employees benefit from the company's profitable periods even with a temporal delay. Is implementation of set-on and set-off optional? No. Implementation is mandatory for all establishments covered under the Payment of Bonus Act, as it constitutes a statutory requirement designed to protect employee interests. This regulatory mechanism creates equilibrium in bonus distributions across varying financial cycles, providing predictability for employees while allowing companies to manage bonus obligations strategically. It ensures equitable participation of workers in corporate success while buffering them from temporary financial downturns, fostering a more sustainable approach to performance-based compensation. Schedule B. How to calculate gross profits for banks. Schedule B outlines the standardized methodology for banking institutions to calculate gross profits for bonus distribution purposes, as mandated by the Payment of Bonus Act. Banking institutions must adhere to Schedule B of the Payment of Bonus Act when determining gross profits for employee bonus calculations. This framework ensures uniformity and transparency across the banking sector. What is Schedule B? Schedule B provides a standardized framework for banks to calculate gross profits specifically for bonus distribution. This ensures consistent application across all banking institutions and provides a fair basis for employee compensation. Starting point for calculation. Banks begin with the net profit figure from their profit and loss account after all standard provisions have been made. This represents the profit after accounting for operational expenses, loan loss provisions, and statutory reserves, required add-back items. Bonuses paid to employees during the current accounting year, depreciation expenses on bank property and assets, development rebate reserve created during the accounting period, any reserves created from profits, bonus payments for previous accounting years, if deducted in current accounts, gratuity payments exceeding statutory requirements, all direct taxes, including income tax and surcharge, provided for the year, rationale for add-backs. These items are added back because they were initially deducted in net profit calculations but should be included when determining gross profits for bonus distribution. This provides a more accurate representation of the bank's actual profit performance. Legal requirement. This calculation methodology is mandated by the Payment of Bonus Act and is legally binding for all banking institutions. Non-compliance may result in regulatory penalties and legal consequences. Mathematical formula. Gross profit equals net profit plus bonus paid plus depreciation plus development rebate plus other reserves plus previous year's bonus plus excess gratuity plus direct taxes. Calculation frequency. Banks must perform this calculation annually at the conclusion of each accounting year, prior to determining the allocable surplus for bonus distribution. Flexibility in methodology. While banks must strictly adhere to this prescribed methodology, proper interpretation of individual add-back components is essential for accuracy and compliance. Connection to set on and set off. The gross profit calculated using Schedule B determines the allocable surplus, which is then managed across multiple years through the set on and set off mechanism described in Schedule A. Banks must maintain comprehensive documentation of their Schedule B calculations to facilitate audits and demonstrate regulatory compliance. This documentation ensures transparency in the bonus allocation process and confirms that employees receive fair compensation based on the bank's genuine financial performance. Schedule C. Computation of gross profits for non-banking companies. Schedule C provides the standardized methodology for non-banking companies to calculate gross profits for bonus distribution by starting with net profits and adding back specific expenses and reserves that were initially deducted. Under the Payment of Bonus Act, non-banking companies must follow Schedule C to accurately determine gross profits for bonus distribution. This calculation begins with the company's net profits and systematically adds back certain deducted items to arrive at the gross profit figure used for bonus allocation purposes. Starting point: net profit as per the profit and loss account. After accounting for depreciation, taxes, and other statutory provisions. Items to be added back: employee bonus. Any bonus already disbursed or provisioned for employees during the accounting year. Depreciation. All depreciation amounts provided in the company's financial statements. Direct taxes. All direct taxes, including income tax and super tax, provisioned in the accounts. Development rebate, investment allowance. Any development rebate or investment allowance reserve created during the year. Other reserves. All other reserves created from the year's profit. Prior year bonus payments. Amounts paid or provisioned for employee bonuses related to previous accounting year's excess gratuity. The excess of gratuity paid over the amount originally provisioned. Statutory compliance. This calculation methodology is mandated under Schedule C of the Payment of Bonus Act and must be followed by all non-banking companies when determining the allocable surplus for bonus distribution to employees. Frequently asked questions: why are bonuses and depreciation added back? These items are added back because they represent legitimate business expenses that were deducted to arrive at net profit, but must be included when determining gross profits for bonus calculation purposes. What constitutes direct taxes? Direct taxes include income tax, super tax, and any other taxes paid directly by the company on its income and profits. Must all reserves be added back? Yes. All reserves created from the year's profits must be added back when calculating gross profits under Schedule C. How does Schedule C differ from Schedule B? While following similar principles, Schedule C is specifically designed for non-banking companies, whereas Schedule B addresses the unique accounting practices and regulatory requirements of banking institutions. Which items should not be added back? Indirect taxes, such as GST and customs duties, and regular operating expenses are not added back when calculating gross profits. When should this calculation be performed? This calculation should be performed at the conclusion of each accounting year when determining the allocable surplus for employee bonus distributions. What follows the gross profit calculation? After calculating gross profits, companies must determine the allocable surplus by applying the percentage prescribed by the Payment of Bonus Act, which then becomes available for distribution to eligible employees. Schedule D. Further sums to be deducted as prior charges. Schedule D establishes specific deductions permitted before calculating employee bonuses. Standard companies can deduct preference shareholder payments, 8.5% of paid equity share capital, and 6% of balance sheet reserves. Banking companies follow similar guidelines with adjusted percentages and additional provisions for statutory reserve funds. Schedule D is a fundamental component of the Payment of Bonus Act that specifies what companies must deduct from their gross profits before determining the available surplus for employee bonuses. These deductions, termed prior charges, Ensure businesses maintain sufficient capital for operations while still providing equitable bonuses. Deductions for regular companies or dividends payable to preference shareholders for the accounting year 8.5% of the paid up equity share capital as at the beginning of the accounting year, 6% of the reserves shown in the balance sheet as at the beginning of the accounting year, excluding revaluation reserves. Deductions for banking companies or dividends payable to preference shareholders for the accounting year, 7.5% of the paid up equity share capital as at the beginning of the accounting year, 5% of the reserves shown in the balance sheet, excluding revaluation reserves. Any sum transferred to a reserve fund under Section 17 of the Banking Regulation Act, 1949. Calculation example for a regular company with preference share dividends: 100,000 paid up equity share capital, 10 million balance sheet reserves, 5 million. The deductions would be: preference dividends, 100,000, 8.5% of equity capital, 850,000, 6% of reserves, 300,000. Total deductions, 1,250, 000. Important considerations: capital and reserves are assessed based on their value at the beginning of the accounting year. Only reserves officially documented on the balance sheet are included in calculations. Revaluation reserves are explicitly excluded from all calculations. Companies with accumulated losses are subject to special provisions. Frequently asked questions: what is Schedule D? Schedule D defines the allowable deductions companies can make before calculating employee bonus allocations. What can regular companies deduct? Regular companies can deduct dividends payable to preference shareholders, 8.5% of their paid up equity share capital, 6% of their balance sheet reserves. What can banking companies deduct? Banking companies can deduct dividends payable to preference shareholders, 7.5% of their paid up equity share capital, 5% of their balance sheet reserve. Statutory transfers to reserve funds under the Banking Regulation Act. Why are these deductions permitted? These deductions ensure companies retain sufficient capital for core operations and regulatory requirements before distributing employee bonuses. When was Schedule D established? Schedule D was implemented as part of the original Payment of Bonus Act, 1965, with subsequent amendments reflecting evolving economic conditions. How are revaluation reserves treated? Revaluation reserves are specifically excluded from the calculation of the 6% or 5% for banking companies deduction on reserves. Do these deductions apply universally? These deductions apply to all establishments covered under the Payment of Bonus Act, with specific percentages varying between banking and non-banking companies. Schedule E. Skill categorization of occupations. Schedule E establishes a systematic classification of workers into unskilled and semi-skilled categories based on training requirements and experience levels. Unskilled positions require minimal training, while semi-skilled roles demand specific practical experience. This framework helps organizations establish appropriate wages, benefits, and create clear career advancement pathways. Schedule E strategically categorizes occupations based on skill requirements, providing essential clarity for both employers and employees regarding job specifications, training needs, and fair compensation structures. Unskilled occupations: builder, cleaner, helper, messenger, sweeper, watchman, porter, packer, loader, unloader, general laborer. Other positions requiring minimal experience without specialized skills. Unskilled workers typically receive on-the-job training and achieve proficiency within a brief period, generally ranging from several days to a few weeks. Semi-skilled occupations: assistant, attendant, cobbler, cultivator, fireman, helper, blacksmith, helper, carpenter, helper, electrician, machine operator, basic, security guard. Other positions requiring competencies developed through practical experience. Semi-skilled workers typically require several months of dedicated training or practical experience to develop the necessary competencies for their roles. Frequently asked questions: what is an unskilled occupation? An unskilled occupation requires minimal training and experience. Workers can quickly master these roles through basic instruction. These positions primarily involve routine tasks that follow established procedures and protocols. What is a semi-skilled occupation? A semi-skilled occupation requires substantial practical experience and structured on-the-job training. These workers have developed specific competencies through consistent workplace experience. They regularly handle tasks demanding attention to detail and fundamental technical knowledge. Why are jobs categorized this way? This classification system facilitates the determination of appropriate wages, targeted training initiatives, and equitable employment policies. It also establishes transparent career progression pathways and helps organizations structure their workforce efficiently. Can a worker move between categories? Yes. Through systematic training and accumulated experience, workers can advance from unskilled to semi-skilled positions and potentially to skilled roles. Many organizations implement comprehensive career development programs specifically designed to facilitate this upward mobility. How do these categories affect compensation? Typically, semi-skilled workers receive higher compensation than their unskilled counterparts due to their enhanced training and valuable experience. Pay scales are strategically structured based on these skill classifications to ensure fair compensation. Are these categories recognized across all industries? While the fundamental concept is widely acknowledged, specific job classifications may vary by industry sector, geographical region, or individual organization. Certain industries may implement more nuanced classification systems tailored to their specific requirements. How do educational qualifications relate to these categories? While formal education provides a valuable foundation, these categories emphasize practical skills and workplace experience rather than academic credentials. Many semi-skilled positions prioritize demonstrated hands-on proficiency over formal educational qualifications. A comprehensive understanding of these skill categories enables both employers and employees to establish clear expectations regarding job responsibilities, training requirements, and advancement opportunities. This framework serves as a valuable foundation for strategic workforce development and organizational planning initiatives. Schedule E categorizes workers as skilled or highly skilled based on specialized training requirements and work precision standards to establish appropriate classifications, compensation structures, and qualification frameworks. Schedule E, Skilled Occupations. FAQs. What is Schedule E? Schedule E is a comprehensive classification system that categorizes skilled workers into two distinct groups based on their training, expertise, and experience levels. It serves as an official standardization framework used by employers and labor departments to maintain consistency in job roles across various industries. What are the two categories in Schedule E? The two primary categories are skilled occupations and highly skilled occupations. These classifications reflect varying levels of expertise, training requirements, technical knowledge, and work complexity. What is a skilled occupation? A skilled occupation requires specialized abilities acquired through formal training or substantial work experience. Examples include blacksmith, carpenter, driver, electrician, fitter, mason, mechanic, painter, plumber, and welder. These professionals typically require 2-3 years of vocational training or equivalent practical experience in their field. What is a highly skilled occupation? A highly skilled occupation demands exceptional precision and comprehensive technical knowledge developed through intensive specialized training. Examples include artificer class I, blacksmith class I, carpenter class I, mason class I, and senior mechanic. These professionals generally require 5+ years of hands-on experience and typically hold specialized certifications, advanced diplomas, or demonstrate mastery through exceptional work quality. How do these categories affect workers? These classifications directly influence job designations, compensation structures, and qualification requirements across various positions. They also establish clear promotion pathways, identify appropriate training opportunities, and sometimes determine eligibility for specific benefits, allowances, or professional recognition. Who determines which category a worker falls into? Employers make these determinations based on established industry standards, detailed job descriptions, and the worker's documented qualifications and demonstrated skills. Labor departments often provide comprehensive guidance through official publications, regulatory frameworks, and certification standards. Can workers move between categories? Yes. Workers can advance from skilled to highly skilled categories through additional specialized training, recognized certification programs, demonstrated expertise in complex projects, and accumulated years of relevant experience. Many employers establish structured career advancement pathways to facilitate this progression. Are wages significantly different between categories? Yes. Highly skilled workers typically earn 30–50% more than skilled workers in the same field, reflecting their advanced technical expertise, increased responsibilities, and the superior precision and quality standards required in their work. How does Schedule E relate to other labor classifications? Schedule E specifically addresses skilled workers, while complementary schedules cover unskilled, semi-skilled, and specialized professional categories. Together, these classifications create a comprehensive framework for effective workforce organization and standardized employment practices. Both categories play vital roles in workplace organization and operational efficiency. The fundamental distinction lies in the fact that highly skilled workers require more intensive specialized training and must consistently deliver work with greater precision and technical sophistication than skilled workers. This structured classification system helps maintain quality standards, ensures appropriate compensation based on expertise, and establishes clear career development trajectories for professionals in technical and trade occupations. A thorough understanding of Schedule E is essential for employers, human resource departments, and workers themselves, as it forms the foundation for fair employment practices, skills-based advancement opportunities, and appropriate recognition of technical expertise in the workforce. Many industries rely on this standardized approach to maintain consistency in job classifications across diverse workplaces, geographical regions, and specialized sectors. Form I serves as an official register documenting employee wages, work periods, and related deductions that employers must maintain as part of mandatory payroll record-keeping requirements under labor regulations. Form I, Register of Wages and Deductions. Form I is a critical document that provides a comprehensive record of wage payments and deductions for each employee. This standardized form ensures transparency in employer-employee relationships while demonstrating compliance with labor regulations. The form captures the following essential information: Employee Register Serial Number 1, Employee's full name 2, Designation Department 3, Wage Payment Duration 4, Wage Period Dates 5, Total Days Worked 6, Total Overtime Hours 7, Basic Salary Amount 8, DNS Allowance, DA, 9, Additional Allowances 10, Gross Wages Payable 11, Employee Provident Fund Contribution 12, Employee State Insurance, EC, Contributions 13, Tax Deductions 14, Miscellaneous Deductions 15, Net Amount Paid 16, Payment Date 17, Employee Signature or Thumb Impression 18. Frequently asked questions: who must maintain Form I? All employers are legally required to maintain Form I records for every employee, regardless of organization size or industry sector. What is the frequency for updating Form I? Form I must be updated with each wage disbursement, typically on a monthly basis. Each entry must correspond to a specific wage payment period. What does DA represent in Form I? DA, DNS allowance, is a cost of living adjustment paid to employees to offset inflation. It's typically calculated as a percentage of the employee's basic salary. Why is Form I considered important? Form I serves as a crucial safeguard for both employers and employees by maintaining definitive records of all wage transactions and deductions. It helps resolve compensation disputes, demonstrates compliance with minimum wage legislation, and provides documentation during labor inspections. Where should Form I records be stored? Form I records must be retained at the employer's premises for a minimum of 3 years and must be readily available for examination during labor inspections or complaint investigations. Is Form I mandatory for all employee categories? Yes. Form I documentation is required for all employee types including permanent, temporary, contractual, and casual workers receiving compensation from the employer. Can Form I be maintained in digital format? Yes. Many jurisdictions permit digital maintenance of Form I, provided the electronic records remain easily accessible, secure, and printable when requested by authorities. What are the consequences of non-compliance? Failure to maintain proper Form I records may result in significant monetary penalties, legal proceedings, and additional sanctions as specified under applicable labor laws. Specific penalties vary by jurisdiction. Diligent maintenance of accurate Form I records fulfills not only legal obligations but also establishes sound business practices that foster transparency, accountability, and trust in the employer-employee relationship. Form I serves as a comprehensive record of all financial penalties and wage deductions for employees, functioning as a legally mandated document that safeguards both employers and workers by meticulously tracking overtime compensation, disciplinary fines, and payment details. Form I, Register of Fines and Deductions. This essential form contains the following key fields: overtime earning, Field 11. Additional compensation earned for work performed beyond standard hours. Nature of acts and omissions for which fine imposed with date. Field 12. Specific description of employee conduct resulting in disciplinary action. Amount of fine imposed. Field 13. Monetary penalty assessed for workplace violations or misconduct. Damage or loss caused to the employer by neglect or default of the employee. Field 14. Quantified financial impact resulting from employee negligence. Amount of deduction from wages. Field 15. Total sum withheld from earnings, including fines and compensation for damages. Total amount of wages paid. Field 16. Final payment after calculating all additions and deductions. Date of payment. Field 17. Official date of wage disbursement to the employee. Attendance date. Field 18. Documentation of days worked during the wage period. Signature. Field 19. Employee acknowledgement confirming receipt of wages and awareness of deductions. All entries must be maintained in chronological order with thorough documentation justifying any imposed deductions or fines. Frequently asked questions. FAQs. Who must maintain Form I? Every employer must maintain Form I records for each employee as mandated by the Code on Wages, regardless of company size or industry. How long should Form I be kept? Employers must preserve Form I records for a minimum of 3 years from the date of the last entry to ensure compliance with labor regulations. What happens if an employer doesn't maintain Form I? Non-compliance may result in significant penalties, including substantial fines and potential legal proceedings initiated by labor authorities. Can employees access their Form I records? Yes. Employees have the legal right to inspect their own Form I records upon request to verify the accuracy of wage calculations and deductions. Are there limitations on wage deductions? Yes. The Code on Wages explicitly states that total deductions cannot exceed 50% of an employee's total wage in any given wage period to prevent excessive financial burden. How should fines be properly documented? All fines must be recorded with precise details about the incident, exact date of occurrence, and specific amount. Generalized or ambiguous descriptions are deemed insufficient for legal purposes. Is employer approval required for all deductions? Most deductions require explicit written authorization from the employee, with exceptions only for those mandated by law or issued through court orders. Can Form I be maintained digitally? Yes. Electronic record keeping is acceptable provided all required information is captured comprehensively and remains readily accessible during official inspections. Important notes: meticulous maintenance of Form I ensures transparency in wage administration while providing legal protection for both employers and employees in case of disputes. The document serves as authoritative evidence of wage payments and disciplinary actions. Employers should prioritize accuracy, completeness, and prompt recording after each wage disbursement. During routine inspections or complaint investigations, labor officials frequently request Form I for review. Well-organized, comprehensive records demonstrate regulatory compliance and significantly reduce complications during official audits. Maintaining proper documentation also builds trust in the employer-employee relationship by ensuring all financial transactions are transparent and justifiable. Form 2. Single application under Section 45(5). Form 2 serves as a structured application for addressing wage-related grievances filed by employees, unions, or inspectors against employers, requiring comprehensive employment details, specific claim information, and clearly defined relief sought. Frequently asked questions: what is Form 2 used for? Form 2 facilitates filing complaints regarding wage issues such as underpayment or non-payment of wages. It provides a mechanism for workers to recover rightfully earned compensation. It functions as an official legal document that initiates the wage claim process under the Code on Wages, 2019. Who can file Form 2? Individual employees with wage-related grievances, registered trade unions representing affected workers, government inspectors, inspector-cum-facilitators, acting on behalf of workers, groups of employees with similar claims against the same employer. Where is Form 2 submitted? Submission is made to the authority appointed under Section 45(1) of the Code on Wages, 2019. The designated authority typically includes the local labor commissioner or appointed wage authority in your district. Several jurisdictions now offer digital submission options through official Labor Department portals.
What information must be included in Form 2? Comprehensive employment details, designation, department, employment duration, complete employer information, company name, address, registration details, specific details of the wage dispute, including payment discrepancies, precise quantification of the financial compensation sought, a sworn declaration attesting to the truthfulness of all provided information, relevant employment dates, and specific periods for which wages are claimed, detailed calculations demonstrating how the claimed amount was determined, what kinds of relief can be requested, recovery of unpaid wages, reimbursement of amounts wrongfully deducted from compensation, payment for uncompensated overtime work, interest payments for delayed wage disbursements, compensation for minimum wage violations, additional wage related payments legally entitled to the employee. Do I need to sign the form? Yes. A formal declaration confirming the accuracy and truthfulness of all provided information is mandatory. Be aware that false declarations may result in claim rejection and potential legal consequences. What supporting documents should accompany Form 2? Employment contract or official appointment letter, salary statements or wage payment documentation, attendance records or time logs, written correspondence with the employer regarding wage dispute, statements from witnesses, where applicable. What is the timeline for filing Form 2? Claims must be submitted within 3 years from the date when wages became due. Resolution timeframes vary by jurisdiction, though authorities generally aim to resolve claims within 3-6 months. Common mistakes to avoid when filing Form 2. Providing incomplete employment information, presenting ambiguous calculations of claimed amounts, omitting essential supporting documentation, submitting claims after the statutory limitation period, failing to retain a copy of the submitted application for personal records for efficient processing. Ensure all information is presented clearly and comprehensively to help authorities resolve your claim promptly and equitably. Consider consulting with a legal aid center or trade union representative for assistance in properly preparing your application to maximize its effectiveness. Form 3. Appeal under Section 49(1). Form 3 enables individuals to formally appeal decisions made under the Code on Wages, 2019, within 90 days of the original order. It requires a detailed case statement, specific grounds for appeal, supporting documentation, and must be submitted to the designated appellate authority. Purpose and overview: this form provides a structured process to challenge wage-related orders you believe are incorrect or unfair. It protects your right to seek reconsideration of decisions that may adversely affect your entitlements under the Code on Wages, 2019. What information must I include in Form 3? Clear chronological statement of all relevant facts, specific grounds, and detailed justification for your appeal, declaration that no other appeal on this matter is pending, exact relief or remedy you're seeking, all supporting evidence, as properly labeled annexures. Where do I submit this form? Submit directly to the appellate authority designated under Section 49(1). Follow the submission protocol outlined in your local regulations. What should I know about the appeal process? Clearly identify the specific order you're contesting, specify exactly which portions of the order you disagree with, provide compelling reasons why the decision should be reconsidered, number all paragraphs sequentially for easy reference, ensure the appeal is properly signed by you or your authorized representative. Frequently asked questions: is there a time limit for filing an appeal? Yes. Appeals must be filed within 90 days of receiving the original order. In exceptional cases with valid justification for delay, the authority may consider late appeals. Can I submit additional documents after filing? While you should include all relevant documents with your initial submission, The authority may accept additional evidence if it strengthens your case and wasn't previously available. What happens after I submit my appeal? The appellate authority will review your submission, potentially schedule a hearing for you to present your case, and ultimately issue a decision that may uphold, modify, or overturn the original order. Do I need legal representation to file Form 3? Legal representation isn't required, but can be valuable for complex cases or when significant amounts are at stake. You retain the right to represent yourself throughout the process. Are there any fees associated with filing an appeal? Some jurisdictions require a nominal processing fee. Contact your local labor department or appellate authority to confirm current fee requirements in your area. Can my employer retaliate against me for filing an appeal? No. The law explicitly prohibits employer retaliation against employees exercising their rights under the Code on Wages. Report any retaliatory actions immediately to the appropriate authorities. For prompt and favorable consideration of your appeal, ensure all information is accurate, thorough, and submitted within the prescribed timeframe. Organize your supporting documents systematically with a comprehensive index to facilitate efficient review by the appellate authority. Form IV. Employee register. Employers must maintain a comprehensive record of 13 essential data points for all workers as mandated by the Code on Wages, 2019. This register requires regular updates whenever employee information changes to ensure compliance with labor regulations. Frequently asked questions. What is an employee register? An employee register is an official record, maintained in physical or digital format, that documents critical employee information required by labor authorities. Why do I need to maintain this register? The Code on Wages, 2019 legally mandates all employers to maintain this information to safeguard workers' rights, ensure proper wage administration, and facilitate regulatory compliance. What information must be included in the register? The following 13 mandatory data points must be recorded for each employee. Serial number for internal tracking, 1. Employee code, unique identifier, 2. First name, 3. Last name, surname, 4. Gender, 5. Father's or spouse's name, 6. Date of birth, 7. Nationality, country of origin, 8. Educational qualifications, 9. Date of joining, 10. Designation, job title, 11. Skill category classification, HSSSSS, 12. Nature of employment, regular temporary contract, 13. How frequently should the register be updated? Updates are required when new employees join the organization, when existing employee information changes, or when employment is terminated. Is a physical register mandatory or can digital formats be used? Both physical and digital formats are acceptable for compliance purposes, provided all required information is accurately maintained and readily accessible during regulatory inspections. What do the skill category classifications represent? HS equals highly skilled, S equals skilled, SS equals semi-skilled, US equals unskilled. Each employee must be categorized according to their skill level, qualifications, and job responsibilities. What penalties apply for non-compliance? Non-compliance with register maintenance requirements can result in substantial financial penalties under the Code on Wages, 2019, with fines determined by the severity, duration, and repetition of violations. What is the minimum retention period for these records? All records must be preserved for a minimum of 3 years from the date of the last entry, though specific industries may be subject to extended retention requirements. Important notes: confidentiality. The register contains sensitive personal information and must be stored securely with access restricted to authorized personnel only. Regulatory inspections. Labor inspectors are empowered to examine these records during compliance audits without prior notice. Format flexibility. While the presentation format may vary, all 13 mandatory fields must be clearly documented and readily accessible for each employee record. Form IV. Employee register. Continued additional mandatory employee information required in the employee register as per the Code on Wages, 2019, and related labor regulations, including contact details, identification numbers, banking information, and residential addresses. Contact and identification details: mobile number, primary contact for official communications and emergencies, alternative contact, secondary phone or emergency contact information, email address. For digital communications and notices, UAN, universal account number, 12-digit number for tracking PF accounts across employers, PAN, permanent account number, 10-character tax identification issued by the Income Tax Department, ESIC IP number. For health benefits, medical services, and disability coverage, Aadhaar, 12-digit unique identity number serving as proof of identity and address, banking information, bank account number. Where wages are deposited. Bank name, financial institution holding the employee's account. Branch, IFSC, Indian Financial System Code for electronic transfers. Account type, savings, current, or salary account. Payment mode, method of salary disbursement, bank transfer, check, or cash. Address requirements. Present address, current residence where employee lives. Present address proof, verification documents, rental agreement, utility bills, permanent address, long-term or family residence that remain stable. Permanent address proof, documents confirming permanent residence. Modern employee register elements. Biometric information, fingerprints or retina scans for attendance tracking. Photo identification, recent passport-sized photograph. Emergency contact, name, relation, and contact details for emergencies. Medical information, relevant health data for workplace safety, blood group, allergies, compliance requirements. Record retention, employee records must be maintained for at least 3 years from the last entry. Digital records, electronic maintenance is permitted if securely stored and easily retrievable. Access authorization, labor inspectors, government officials, and the respective employee may access their information. Non-compliance penalties, fines ranging from 10,000 to 50,000 based on violation severity and frequency. Form V, wage slip, a mandatory document issued to employees detailing compensation information. This legal record contains employer details, employee information, and a comprehensive breakdown of earnings and deductions, ensuring transparency in wage payment. Employer information, name of the establishment, legal business name, registered with authorities. Address, complete business location including city, state, and PIN code. Period, specific time frame covered by the wage payment. Company registration license number, official business identification number, PAN/TAN number, tax deduction and collection account identifier. Employee information, name of employee, full legal name as per records. Father, spouse name, secondary identification reference designation, official job title or position. UAN, universal account number for Provident Fund tracking. Bank account. No account for wage deposits. Wage period, payment cycle, daily, weekly, fortnightly, or monthly. Employee ID code, internal identification number. Department, division, specific organizational unit. Date of joining, employment commencement date. Wage details, rate of wages payable, basic salary, core compensation component. DA, dearness allowance, inflation adjustment. HRA, house rent allowance, conveyance allowance, transportation compensation, special other allowances, additional benefits, total attendance, unit of work done, days worked, shifts completed, or production units. Overtime wages, compensation for extra hours worked. Gross wages payable, total compensation before deductions. Total deductions, PF, Provident Fund, retirement savings contribution, ESI, employee state insurance, health insurance premium. Professional tax, state mandated occupation tax. Income tax, TDS, tax withheld at source. Loans, advances, repayment of borrowed amounts. Others, additional authorized deductions. Net wages paid, final amount after all deductions. Payment mode, method of disbursement, cash, check, bank transfer, digital payment. Frequently asked questions. Essential information about Form V, wage slip. Who must issue a wage slip? All employers must provide wage slips to employees on or before payment, regardless of organization size or sector covered under the Code on Wages. How often should wage slips be issued? Wage slips must accompany each payment cycle for daily, weekly, fortnightly, or monthly for matching the established payment frequency. Can wage slips be sent electronically? Yes, electronic wage slips are permitted when employees have computer access and have provided consent, aligning with modern paperless initiatives. What are the consequences for failing to issue wage slips? Non-compliance constitutes a labor law violation subject to penalties under the Code on Wages, with escalating fines for repeated infractions. How should employees address wage slip errors? Employees should promptly report discrepancies to HR or payroll management while maintaining personal records of all wage slips for verification. What is the retention requirement for wage slip records? Employers must preserve wage slip documentation for a minimum of 3 years, though some jurisdictions may require longer retention periods. Must employers explain wage slip components? Yes. Employers should ensure employees understand their compensation calculation and component breakdown, fostering transparency and preventing disputes. Is it permissible to make undocumented deductions? No. All deductions must be explicitly documented on the wage slip, for undisclosed deductions violate labor laws. A properly formatted wage slip serves dual purposes, fulfilling legal obligations while building employee trust through transparent compensation documentation. Form 6, Application for Composition of Offense. A formal document submitted by employers to resolve Code of Wages violations through administrative settlement rather than judicial proceedings. This process requires detailed information about the applicant, specific violation details, and relevant legal provisions. Required information: personal identification, full name, parent/spouse name, complete residential address, comprehensive description of the alleged violation, specific section and subsection of the code that was violated, maximum statutory penalty applicable for the violation, disclosure of any pending litigation related to the same matter, declaration regarding previous violations of similar nature, precise date, time, and location where the violation occurred, sworn affidavit confirming accuracy of all submitted information, authorized signature, with date of application, submission process. Submit the completed application to the designated competent authority appointed under the Code on Wages. Applications must be filed within 60 days from the date of violation notice receipt. Each distinct violation requires a separate application form. All supporting documentation and evidence must accompany the application. Benefits of composition: eliminates protracted legal proceedings and associated court appearances, typically results in reduced financial penalties compared to court-imposed fines, expedites case resolution, often within 30 days of application, substantially reduces administrative and legal burdens for both parties, preserves business reputation by avoiding public litigation records. Frequently asked questions: what is composition of offense? A legal mechanism allowing settlement of certain violations through administrative channels by paying a prescribed fine, thereby avoiding criminal prosecution and court trials. Who can file Form 6? Any employer facing charges under the Code of Wages who wishes to resolve the matter through administrative settlement rather than judicial proceedings. Is composition of offense available for all violations? No. Only specified minor and moderate violations qualify for composition. Serious violations, willful non-compliance, or repeat offenses generally require full legal proceedings. What happens after Form 6 submission? The competent authority reviews the application, verifies the information provided, and determines whether to permit composition. If approved, a composition order specifying the settlement amount is issued. How is the composition amount determined? The competent authority calculates the amount based on violation severity, statutory maximum penalties, compliance history, and mitigating circumstances presented in the application. Can my application be rejected? Yes. Rejections occur if the violation is non-compoundable. There's a history of similar violations, the application contains material misrepresentations, or the composition would not serve justice. Is there a time limit for the authorities to respond? Yes, the competent authority must issue a decision within 30 days of receiving a complete application with all supporting documentation. Does paying the composition amount mean admitting guilt? Yes, accepting composition constitutes an acknowledgement of the violation, though it carries fewer consequences than a court conviction. Legal implications: once an offense is compounded, no further legal or disciplinary action can be initiated regarding that specific violation. The composition order is legally binding and cannot be challenged through appeal or judicial review. Composition records may be considered as compliance history when evaluating future violations. Non-payment of the agreed composition amount by the stipulated deadline may result in automatic reinstatement of criminal proceedings. Implementation and enforcement: the Code on Wages rules establish a comprehensive framework for equitable wage practices across India, encompassing payment protocols, documentation requirements, and sophisticated dispute resolution mechanisms for workplace compensation issues. What are the Code on Wages rules? The Code on Wages rules provide a robust regulatory framework designed to implement and enforce wage-related legislation consistently throughout India. They ensure timely and accurate disbursement of wages to all eligible workers. These rules consolidate and supersede 4 previous labor statutes: the Payment of Wages Act, the Minimum Wages Act, the Payment of Bonus Act, and the Equal Remuneration Act. They establish a unified legal architecture applicable to all establishments and employers across sectors, promoting standardization in wage administration. What do these rules cover? These regulations mandate comprehensive record-keeping practices, timely wage disbursements, and precise minimum wage calculations by employers. They provide transparent guidelines accessible to both employers and employees, enhancing compliance and awareness. The rules delineate payment frequencies, authorized payment methods, and permissible deductions from wages with clear parameters. They outline systematic procedures for determining and periodically revising minimum wage rates based on skill classification and regional economic factors. The rules enforce equal compensation for equivalent work regardless of gender, addressing systemic discrimination in workplace remuneration. How are complaints handled under these rules? For wage-related grievances, the rules establish a structured, progressive resolution system designed to address concerns efficiently. This framework includes specifically appointed authorities empowered to adjudicate complaints, and appellate bodies authorized to review contested decisions. Claims must be initiated within prescribed limitation periods, typically within 3 years from the date of the alleged violation. The rules authorize inspectors to conduct workplace assessments, examine employment records, and verify compliance with statutory requirements. Comprehensive conciliation procedures are established to facilitate amicable dispute resolution prior to formal adjudication. Penalties for non-compliance employers who violate wage payment provisions face substantial financial penalties, potentially extending to $50,000. Repeat violations may trigger escalated sanctions and possible incarceration in particularly egregious cases. Inadequate or improper wage record maintenance constitutes a separate offense with distinct penalties. The regulatory framework empowers authorities to recover unpaid wages on workers' behalf, with additional compensation available in appropriate circumstances. Benefits of compliance. Adherence to these regulations fosters positive industrial relations and enhances workplace morale and productivity. Compliance significantly mitigates legal exposure and potential operational disruptions for businesses. Properly implemented wage practices contribute substantially to financial security and economic stability for workers and their dependents. Transparent and equitable compensation systems enhance employer branding and facilitate recruitment and retention of skilled personnel.